Fresh matter, my lord, on Wednesday.
In item number 6, I have filed an additional affidavit, my lord. I may be allowed to bring.
I pay for listing motion.
Motion. When?
Wednesday.
Wednesday.
My lord, I pay for my lord. Record, my lord. Additional affidavit. Additional affidavit that filed on Saturday, my lord, in terms of your lordship order. That may apply.
My present lordship, I am praying for listing of admission lordship.
Admission after vacation.
A date after vacation, when not?
After vacation, 4th of May. 4th May.
For motion, my lord, can be on Wednesday.
Wednesday.
For orders, lordship, content matter, lordship, 22 lordship.
27.
For motion, lordship.
Wednesday.
Lordship, with the consent of the other side, lordship, I beg to mention item number 20, lordship.
20?
20, lordship. Kindly adjourn the matter for the day, lordship.
0.
20.
Item 20, the request made on behalf of MSE Gauhati stands deferred to be listed after 4 weeks.
Okay, date.
Next of May.
Wait. In item number 61, myself and my co-wife, we have arranged, we reached the compromise. Make also the records of the action activity. And the lordship permission, may I pray for two motion? Motion.
Tomorrow?
Thank you, lordship. I would like to mention item number 17. Kindly adjourn it and sit after vacation, my lord.
Item 17, you are for the petitioner.
I'm the petitioner, man.
Your name?
I am G Das on behalf of S.G. Roy, man.
Mr. D. Das, on behalf of Mr. S.D. Roy. Please forward and 3 weeks time. Request of Mr. So-and-so counsel. 3 weeks.
Lordship, praying for requisition of an affidavit in regard to item number 52.
Want to file an affidavit in reply?
Lordship, already filed, but for requisition.
52.
So,
Have it after vacation.
Lordship,
It be after vacation. When did you file it?
Lordship, on 2nd of March, April.
2nd of April. Let it come on some other date. Item 52. Be listed on 27th of April. The affidavit in reply stated to be filed by the petitioner. List accordingly. Yes.
Lordship, it's for requisition only.
I know, but the matter is listed today. It should come along with the affidavit. We have not gone through the affidavit.
No, this other side, I beg to mention item number 46.
46 to 48. Go forward.
I'm for the petition, your lord, in item number 46, and I've taken the concern of other council there.
46 to 48. On joint request made by the council for the petitioners, matter stands deferred to be listed after 3 weeks.
Pleasure.
Admission matter 27th of April. 27th.
It's suspension matter. Kindly.
After vacation. 20. 0.
Awesome.
Hey, please, your lordship. Lordship, I beg to mention item number 28. Matter may be adjourned for the
Item 28.
My lord.
The request made by the council for stands deferred to be listed after 2 weeks.
Deeply of please, your lordship. Item number 30.
30.
35 of the daily list.
35.
And I don't have matter for today.
Item 35. You are mentioning on whose behalf? On whose behalf are you mentioning? Petitioner, respondent,
Petitioner.
petitioner? Petitioner. 35 on the request made on the council. We have now listed, but we listed. Yes,
Letter be posted on 23rd.
not 23rd. Some date will be given. Yes.
I beg to mention the matter which was listed for on 12th November and fixed for after 2 weeks. But till that the matter has not been dated, listed. So
27th April.
20th April.
20th April, all right. 20th April. 20.
Instruction to introduce the
Council for the petitioner submits the legal instructions to withdraw. Petition. Same stand dismissed on withdrawal.
published.
That's my name of the body.
MSG, alright, is for the respondent.
Chief, my name is it's item number 34.
Thirty-four. Who's your senior?
So
Get your instructions properly before. 35. Any instructions here?
Yes, Lordship. Item number 3 and 4, I have specific instruction because these all are been cases which are already been recommended by the SLC Lordship. They were waiting for the opinion and do the needful Lordship. There are similar other cases, Lordship. The same stand has been taken by the department, Lordship.
It's hardly a stand, you're waiting for opinion.
Lordship.
You're waiting for your legal opinion.
Huh.
There is not a stand. When are you likely to have the opinion?
That I am not sure, Lordship, but as these are under consideration, Lordship, there are similar other cases which are already been disposed of, Lordship.
Where are the orders?
Lordship, right now I don't have the orders, Lordship. I have to search, Lordship.
Your Lordship can dispose of the matter, madam. It's very clear. You recommend
Yes.
wrong back, madam. And my lord, the department has a the postcard here.
No, what order you want?
If the issue the appointment order.
Exactly,
because
so
it's
therefore we need their instructions on record.
Instruction,
If they don't come, then we'll pass an order, but we have to
They
give
have
them an
not come.
opportunity.
yes.
We've not even issued notice in your matter. We'll have to give them some opportunity to bring the instructions on record. Third, then the council for the petition. State council accepts appears on behalf of the
Steps already taken, my lord.
Steps taken, Lordship.
respondents.
I am appearing for the state Lordship SLC. and
Has
the-
notice been issued? Notice has not been issued.
No, notice not issued,
but
Lordship.
Steps taken, my lord. The lordship directed to the corporation.
MS M. Bhattacharya. State council accepts notice. Here's an acceptance on behalf of respondent number 3. MS 1, 4 and 5, 4 and 6. Finance, Mr. R. Portuzari for 5. Present and respondents are represented by the respective counsel. This is the way it is to be furnished. If not overly furnished, respondent will complete their instructions and file necessary affidavit.
Lordship.
The
After
date may be
returnable
fixed,
date.
my lord. The date may be fixed, my lord. Otherwise, my lord. And they should be given
Let
last
it
time
be-
for already
Let it be on 8th of May,
28th of May,
8th.
8th of May. And my lord, that day particularly your lordship can direct that my lord, they should get the instruction, otherwise the matter will be disposed of.
May you renew your prayer, we'll consider.
Deep
On eighth.
noted.
Because this are sent lordship. Saying and done for. My lord, admission matter, my lord, that will be again pending for long.
There has to be a process. We can't, we may issue an order, but it has to be implemented. Unless we find out why the order has not been implemented.
Government secretary and everybody has asked to issue the appointment order. Why the personal
They are
department?
waiting for some legal opinion. Let us see what opinion comes.
Obliged, my lord.
After I'm getting located in the another department, they submitted the technical resignation, and for the respondent authority for their payment of issue.
Any instructions, Mr.
Well, this is come for the first thing.
Counsel?
Was something.
Mr. Dina.
123.
123
3. 4 is APDCL.
for APTC.
It's my friend.
D. Gogoi. So respondent the rebel. Start with 10. Yes.
Seven miles, the CGC, Miss B. Sharma has informed me that she's on legs, been taken after Miss B. Sharma, visitors, CGC. After, public. The pertaining to risk and hardship balances. Your lordship has passed order, my lord. Page 47.
Yes. Third counsel to party. Should not be 7.
The third round of litigation lawsuit is compassionate appointment. Pursuant to the, after the death of my father on 11/10/2010, I have applied for compassionate appointment on 29/11/2011. This is very important. Also, I am agreed by the interim order at page 91, by which my claim has been rejected. Despite this honorable court's order, earlier round of litigation lawsuit.
Who's for the respondent? Who's for the respondent? Yes. We issue notice here.
Yes.
Third counsel to party. Which. Mr. Doctor. AM Doctor, APS. We have all the response. It's the matter after the.
Right. Pertains to repeated extension of suspension. One find the C page 37 past extension without any review. 37.
Proceedings initiated.
Initiated. Proceeding initiated, my lord. Otherwise, within 90 days, my lord, charge sheet submitted. And so extension has been done, my lord. But our case is that, my lord. Kindly see page 37, my lord.
37.
37. First extension, my lord. There is no review, nothing, my lord. And then, my lord, second extension, my lord. My lord, page 37 is first extension. First extension.
But proceeding is going on.
Yes,
Yeah.
my lord. But my lord, it shall be a periodical review has to be done.
So was the judgment.
Judgment, my lord, it is, my lord, poem also itself affected, my lord. Page 38. Last part.
Within 6 months.
3 months. Last paragraph, my lord. Bottom, my lord.
This is for compilation of report.
And for periodical review, my lord.
A periodical review, you have to compile reports and file. This is meant for the department. But show us the judgments on which you are relying, that it must be within 3 months, and otherwise it has to be interfered with. More particularly when there is a departmental proceeding going on. The request made by the council petition, matter time is referred to the state again. Day after tomorrow. Day after.
The cover case for non-payment of income pay scale. This page 61.
Bindas.
Here, madam, we will like to find our affidavit.
Why?
No, madam, apparently not covered. Because lot many matters are coming in this, madam, that the parameters laid down, vendors is absolutely not covered. The persons who are appointed.
Subject to verification.
Subject to verification.
You verify, and if they are not covered, then we are not saying pay them. We are saying if they are entitled under Upendas. That's it. Page 61.
Item 13 is similar.
This is item number 11.
This is item 13.
13 also similar.
I not only the one aspect of the matter, which with all aspects, minor in item number 11, minor. If lordship will be pleased to see my lord's order, minor. For a moment, minor.
Yes.
362, minor. That's your lordship order, minor. If I may read it, minor, paragraph number 6, minor, with all aspects. Considering the same, the respondent authorities are directed to grant the petitioners the benefit of minimum pay scale in terms of. Before granting them benefit, the respondents will be at liberty to make necessary verifications as may be required. So far as the first line in concern, it appears, so far as the first line in paragraph 6 is concerned, it appears, with all respect, if it is a mandamus, considering the fact that the respondent authorities are directed.
Then what is the meaning you ascribe to the second line?
That is true. But some clarification,
No clarification is required. We are giving you liberty to make necessary verifications. Verify. If you think that they are not covered, they are not covered. Give your reasons. What else is verification for?
That is true, but
No, no.
Lordship allows me to file my
No,
affidavit.
supposing we say that you will make verification whether this is satisfied, that is satisfied. What is the point in disposing the matter without expressing anything on merit? We are not deciding it on merit. We are saying that they claim to be covered under the similarly situated like those in Pendas. The department is to make verification.
The finance department, otherwise, if lordship is allow.
No, you give us a reason why you want to verification, why you want to file your affidavit.
But apparently, my lord, the petition as in this present case, my lord, appears not to be covered by lord by dictamin offenders, my lord.
Wait,
For the reason, my lord, that 10 years is there, my lord, and second, my lord, after my lord, 1st of September 2005, my lord, those who are appointed post my lord 2005, my lord, they are not covered under the AFRBM Act also, my lord. Because nowadays, my lord, the lordship will kindly see, my lord, every kind of appointments are being made, my lord.
all these are these issues in the Vendas.
Well,
Vendas is a case where there was a claim for regularization,
that is true, my lord.
right? So the court, on the basis of the submissions of the state, have held that if they are not entitled, but they will be given that benefit.
That is true, my lord. Then that's one of those petitioners who were appointed, my lord, much prior to my lord, were coming into force of that act, my lord, 2005 act, my lord. So that is the difficulty, my lord. So once it reaches the finance department, my lord, it becomes very difficult for us, my lord.
They are asking for filing objections.
Lordship may be please to fix any date, my lord.
All
for
right.
the
That's
convenience of the-
yes, sir. That's the case for come, my lord. This is the supplement of the PTC, my lord. PTC has no objection. Now, when the PTC will verify the matter, then if my name is not included, they can drop it.
BTC is your employer, quite right. The question is the finance will have to give the approval.
Thereafter, my lord, after verification.
All right, but if they say that you are not at all covered under the rules, they are entitled to raise that objection. You are entitled to meet it.
Yes, but the offenders I am in the. Let them
What they
verify,
say
my
they're
lord.
not. If they want to raise an objection, should we debar them? You have to give them opportunity.
They got the finance department.
They're entitled to raise an objection. They're not accepting that this is covered. They'll have to be given an opportunity.
They can, well, if I am not interested, but after verification, let them work my name. I am not interested. Dispose of the matter, let them verify the matter.
No. If they're raising an objection, we keep it. Our counsel for part disposal. Mr. Jari is the PTC department, PTC authority. Mr. R. Borgari, standing counsel is for the finance, according to the standing counsel finance.
For respondent 3, my lord.
For respondent three, the writ petitioners cannot be given the bit of the directions issued in the case of Vendas. That this petition has been appointed after AFRBM.
Yes, my lord. After, my lord,
AFRBM.
after, my lord, coming into force of the AFRBM Act, my lord, 2005.
Petitioners in present proceedings are not similarly situated as those. I would like to bring on record the relevant review by filing an affidavit. Such circumstances, this court considers it appropriate to issue notice making it relevant after.
Lordship, I am impressed.
Let the matter be listed again on 8th of May,
My lord.
by which date the respondent will complete their instruction and file necessary. So 11 and 13 returnable 8th of May.
For the same.
8th of May.
Lordship, I am appearing for this.
PTC. We have recorded.
I'm so obliged.
Can I, my lord, order, my lord, please, 45, my lord. Bring the executive order. Only, my lord, close the one surplus two, my lord, I will fill in, my lord.
When did your father expire?
Ship, other expired in the, 17/2/2012, my lord, and, this honorable court, my lord, directed to, consider my case, my lord, case,
page 27, my lord, in the WBC number 346 submit 2023, my lord. Page 27. And my lord, last paragraph, in view of the aforesaid fact and circumstances, though no fault is attributed to the SLC for rejecting the case of the petitioner as the ground for such action is found, SLC is directed
Get
to make
instructions
fresh.
here.
Yes, that's it. That specific instruction.
Third
required.
counsel for parties. We claim application. File with the authority. Consideration. Response. Directed. Disposed of the matter. Direction to the SLC. Fresh assessment for case of the petitioner for appointment of professional ground. After that, what happened? Your case was considered.
No, my lord, my case was not considered.
What is this order on 18 September 24?
15 September, my lord, this is office memorandum, my lord. This office memorandum, my lord. Thereafter, my lord, order was issued, my lord. As per executive order, my lord,
You are challenging the office memorandum.
office memorandum and the executive order, my lord. Both.
Submits that in spite of the order passed on the court bench dated for case of the petition. 9/20. Subsequent executive passed. So when dated 18/9/20. Executive. Accepts for three. Third vote, this one is number 1. Respondents are represented.
The last question by the election commission was asked to furnish instruction, my lord.
Additional affidavit.
that has been filed to bring on record that whether the, before passing the imping order, whether the petitioner was working here, my lord, appointed as sector officer, my lord. That has been brought in, my lord.
But by what document are you?
Page 44, my lord. Lordship.
Where is the name of the petitioner?
Yes. It's type copy, page 44, and then, my lord, original copy is there also from 46 onwards. 47 page, 47, my lord, name appears as sector officer. This is a copy of appointment as sector officer on 21/2/2026.
Which LLC?
My lord, Paka Betpari. LSC 25, Paka Betpari.
Yes. Election Commission,
As per instruction, appointed as sector of.
so he cannot be transferred.
So, my lordship, kindly see page 23,
Oh,
guideline, guideline of the election commission. Paragraph, page 24, 3. Hence, the commission has decided to no officer concerned directly with election shall be allowed to continue in the present district, revenue district of posting. He or she is posted in a district. Because the petitioner is the home district, he is transferred from the home district. That is the point, man.
now what about 7?
7-3.
7-3 is, my lord, those who are not belong to the home district.
It doesn't say so.
Its categories of officer not covered under transfer policy.
What happens when he's district?
Lordship, that's why the, clause 7(3), Lordship.
Uh.
Second line, however, the observer, COs, and RO should keep close watch on their conduct to ensure that they are fair, non-partisan.
If there is anything as such, my lord, they can.
No, this is the general instruction.
Yes.
What your guidelines in clause number 3 has very specific areas. One is home district.
Yes.
Yes,
So anybody in home district has to be transferred.
always, my lord.
Now,
Always.
whether this is an exception,
As per instruction, Lordship, they are covered under 7(3).
Is the election commission is the competent authority, my lord. And that is specified in 7 categories of
no, in
officer.
respect of this writ petitioner, election commission,
Yes.
in respect of this petitioner, your instructions are that he is exempted under 7(3).
Lordship,
70, provided he is not in the home district. That is the.
Where is the
that is
provider? Election
provider
commission is
is
not
not
It is
open.
for the election commission to
Yes,
interpret
yes.
their it is their
So, page 24, the first column
On
says,
the-
my
on
lord,
that,
home
lordship,
district.
anything. Have you brought anything in writing? Any instructions that you have? No, this is from district commission.
He is the election officer of the district.
Anything from ECI in respect of this clarification?
Nothing. The authority of home district, they
District
cannot
was
be
my lord,
state.
7-3, lordship, kindly have a look on
On a
7-3.
plain reading, Mr. Surya, on a plain reading, it appears that his transfer policy in clause number 3 is exempted under those conditions specified under clause 7.
That is, I have gone through it. ma'am.
Ah.
So, these officers cannot be transferred because it is covered exempted. But those who are in a part of home district, they are to be, initially they have said in a clause 3, if it is the home district, they can be transferred.
No, please read clause 3, very clear.
And
Please
that
read
is
clause
underlined.
3.
Yes. Hence, the commission has decided over 7-3.
Yes.
The officers appointed as sector officers, general officer involved in the election or duties are not covered under these instructions.
Right.
However, the observers, CO, DO, and RO
should keep a close watch on their conduct to ensure that they are fair and non-partisan in their performance of their duty. Because this column is why given, my lord, those who are in their home district, there is a apprehension may be there.
On what basis are you drawing this in?
No, my lord, my apprehension is, my lord, I am saying, my lord, clause 3, page 24, specifically say.
And then clause 7 says, my lord's category. Lordship kindly see
Clause
seven.
3 is the general policy.
policy,
Clause 7 are the exceptions.
exception.
And clause 7.3 is very clear that sector officers, zonal magistrate are not covered.
Not covered under
In similar cases, Lordship has already passed an order. my lord.
Similar case, those who are from home district, they are to be good.
That is also home district, my lord. Lordship has passed.
Where is that order?
On the last occasion, I have funded, my lord. That is on record. Last occasion, I have funded. Lordship has passed the order.
Fixed, my lord. And after, this after two.
Only after one year.
Election, my lord.
That is why in deed petition number, my lord, item number 16, an order was passed by the district.
Election Commission, you get your instructions specifically whether this man is required to be given that responsibility or not. Get it by 2 p.m. Get the instructions whether this man is required for election purposes.
My lord,
or
Lordship,
not.
kindly see, Lordship.
Get it
Next
by
item,
2 p.m.
item number 16, Lordship, kindly see. Lordship, kindly see. That will make everything clear.
Huh?
Item number 16. Item number 16. What the requirement, my lord, Election Commission has passed an order. Page 35. Page 35. Annexure 4. Whereas in connection with the upcoming general election for the Assam Legislative Assembly, a detailed training schedule has been made for the different teams formed to carry out the election work. Several training programs for the members of these teams have already been completed. And whereas the model code and conduct for the general election to the Assembly 2020 is now in force, and only a few days are left for the polling to take place. And whereas it is very important that all officers and officials assigned to election duties remain available without any interruption for the smooth and timely completion of the election work. Then, my lord, now therefore to ensure the smooth conduct of the general election to the Assembly 2026, all head of department in Nagaon district are hereby instructed not to release any officer or officials working under them on transfer from the district level for any work without prior permission of such. That instruction is already there, my lord. Election Commission has passed on that. Returning officer is the election.
It's a training, well, training is applicable to everywhere. Suppose
Those who are
a person
engaged, my
belongs
lord,
to
in election
Kolkata,
duties,
he
they are
has
not
taken
supposed
the
to
training.
In your instructions, there is only it shows that the person is appointed as a sector.
Sector officer.
That instructions were not required, not disputed by anyone that he was appointed as a sector officer. This
My lord,
case,
on the last occasion, my lord.
will you please allow us to
Sorry.
have an interaction? Please
Sorry.
take your seat.
Sorry.
Please take your seat. The case of the petitioner that he is a sector officer. He is appointed as a sector officer. Therefore, ought not to have been transferred in the case. You are required to get instructions there. Your instructions are that he is appointed as a sector officer. There is no dispute on that. No instructions required. Instructions are being a sector officer, whether 7.3 is applicable or not. Get it by 2 p.m.
But on the last occasion, the transfer order was after the question that was raised was after the 15th. order. That's my question. Appointed prior. I got to. For the clause 7.3, I'll get it.
Yeah, that is the only area where we require instructions. If the 7.3 is applicable per se, then he is entitled to an order. This transfer order has to be interfered with. But if 7.3 is not applicable to those officers in the home district,
I'll get
get it by 2 p.m. Mr. Chaudhary at 2 p.m.
That's okay.
Oh, please, Your Lordship, the engaged counsel leave on some other court, kindly take the matter of the same.
Sometime.
Maybe the the petitioner was promoted to the post of foreman on 25/2006. Thereafter, a benefit has not been given. Then benefit lordship will find at case number 15. Decision of pay on promotion on or after first day of January 2006. Last period.
Yes.
And Madam, after I find the representation, Madam, the principal has Madam to the letter to the director that your lordship will find at page number 20.
Number?
20, Madam.
Oh.
Here, Madam, this letter reads as Madam. May I read this letter? With reference to subsection, I had the honor to inform you that Senior Sorenso was promoted to the post of Senior Staff Foreman to the institute, right? Order dated so and she joined as foreman on so. However, as per the application submitted recently by the incumbent, 3% promotional increment benefit was not done by her, as well as not dispersed at the time of promotion. Now, I would like to kindly seek your advice in the matter necessary remedial measures for regulation of so promotional benefit and provide the necessary areas effect on the date of joining of the foreman. It is so, which may be entitled as per government norms, ROP, again. And
Third.
last request,
Any instructions today?
Why not?
Do you have any instructions? Third, let it come. Yes.
And for 1 and 2. Yeah.
Here, more, one and two. Who's for 3?
but the principal, Madam, the principal,
Standing counsel,
Notice may go on. I cannot take.
however. So appears for 1 and therefore notice is okay. Extra copy furnished. 1 week. Stop steps on respondent number 3 by speed in 1 week. Let them still immediately after. Respondents become instructions and find necessary evidence.
the penalty of this case will not be a bar.
Pendency of this case will not be a bar. The respondent authorities to grant the pay benefit.
Yes, Madam.
Pay benefit, the petition is clear.
Upendas.
Upendas. What about Upendas? What has happened to Upendas?
Owner appointed prior to 1/4/1993.
Yes, Mr. Bhotagur?
My lord, a verification process can be done, my lord, if they approach individually, my lord. If they approach individually with their credentials, my lord, then a verification process may be done, my lord. Along this line, my lord, may dispose this.
Their cases have not been considered, therefore they are before the court.
Yes.
If you want to file your response with regard to each of these persons, you file it.
Will file response. Notice may be issued.
Third, consent for the parties, should notice return. Mr. Rai. All,
One,
except three, one,
3, 4,
5, 6.
5, 3. No. Not 3, man. 3 is fine.
Three, finance are both. Three. Respondents are represented by the respective counsel, which is the way the extra 1 week. We have recorded your name for respondent 3. Finance.
Petition is on the deemed suspension, because the rest in connection with the case matter.
Petitioner is.
And the deemed suspension matter, page 26. But was arrested in connection with the case matter, allegation lodged by one of his colleagues, man. Now thereafter, it was reviewed again, that is that
No proceedings.
proceeding has been show cause been issued by charge.
You filed your
I
reply.
have filed my reply. Thereafter, it is not proceeded.
When was the reply filed?
Reply was filed, my lord, on 26/12/2025, man. And my lord, it was renewed last, my lord, on 23/12/2025, man. Page 44. Thereafter, also 90 days has gone, my lord. Subsequent renewal has not taken place. I also preferred an appeal that is yet to be disposed. That's pending.
That was pending before the lordship, GAD department lordship. Here is GAD is the council, in the party lordship, but name has not been shown lordship.
You filed your appeal.
Yes, I filed my
What happened to the appeal?
Well, I think my lord is at page, my lord, 48, my lord. That is yet to be. But then, my lord,
Get instructions, what has happened to the appeal?
Lordship,
Page
appeal was
48.
pending before the GAD lord. GAD is a
GAD.
member council lordship.
GAD is not a count. Why have you filed before GAD?
because the GAD is the authority, man. He's under GAD, man.
You are appointed.
The deputy commissioner's office, my lord, but it's the general department.
Appeal before the GAD.
So you have to arrange the GAD.
There's a party,
Is a party respondent lordship.
Who is the, where is the counsel for
Name has
GAD?
not been shown lordship.
Name may not be shown, you call him.
Fine.
Call the GAD, counsel. GAD. After a while.
With your lordship. Lordship, I was asked to obtain instruction. I'm waiting for instruction and anyway, lordship, he is protected till 15th of May. So lordship may issue notice returnable in the first week of May, lordship.
Mr. D. Boyle and counsel for the petitioner, D. Sharma. Is since Ms. Sharma is the period of still again no. Since the movement orders have been deferred till 15th of May by subsequent orders, prayer for interim may be reviewed by the counsel for the petitioner if required on the next returnable. Extra copies be furnished within 1 week.
All right.
Pass orders. Dictate orders. 21. Mr. Nayak, we'll appoint the arbitrator here in item 21. We'll pass an order.
Just one liberty, then I'm praying for Lord. Lordship will grant me the liberty to raise the issue of jurisdiction before the tribunal.
Absolutely. All grounds.
But
All-
the ground that those I mean, raised
No,
before this
we are,
honorable
we
court.
are, we are holding that this is the law that the arbitrator is competent to decide on everything, including his own.
Lordship. That one line of the objection. Copy was first side of the government. That's why
You get your instructions, what has happened to the appeal which is filed before the commissioner and secretary really.
I'll do that.
You, Mr. Doctor will furnish an extra copy.
Fine.
Matter we listed 20 April.
I've given.
By which time the council really studied. When it's taken on 20.
Realistic and list our name also.
No. Note down, we are fixing the matter on 20.
20th.
Don't rely, don't burden the registry. Whatever names will appear, will appear. Make a note, we are fixing a date, that's the whole purpose.
May I please, Lordship, instruction received, Lordship, but that instruction are not sufficient, Lordship. For the 2 weeks time will be granted, Lordship.
Mr.
I'm MP.
M. Sharma, yes. 2 weeks further time. Mr. Sharma, MP Sharma for Commissioner, Mr. Immediately after. Fourth of May.
Apply. It may come up for admission.
Why is it for orders?
Lordship, not on the last session, but before that, Lordship. Voluntary exam and Lordship. But then I have challenged the promotion of one leader to do Lordship. That immediate persisting Lordship. That's the.
As per 12/6/2025.
Obliged.
Fourth of May.
The Lordship may kindly grant us some time. Sir, Mr. J. Henry was supposed to place the instruction. He is having some difficulty. Can you give some time? Otherwise, after dismissal of the appeal, the action has to be taken by the
What is the direction?
direction of the honorable court is to consider his
To reinstate.
to reinstate. Operative portion, Lordship will find at page 16. 17, para 17.
passed on 10/9.
Yes. Thereafter, the
2024
an appeal was preferred. The appeal was dismissed on 6/1/2026.
That means the minor can how they mislead this honorable court, my lord. After passing of this order, my lord, on 24, the year of 24, thereafter, this is the minor, my lord. This is the minor, the meeting of the disaster management. Can you see paragraph, third paragraph? Thereafter, they filed, my lord, appeal. Appeal was dismissed. We okay. Direction, my lord, from the share function.
Is Iqbal Hussain the petitioner?
Petition, my lord.
You get instruction, there appears to be a consensus for reinstating him in the meeting. Do you have extra copies?
Yes.
Give him one copy. Get your instructions.
Lot.
The request made by the government state, by Mr. D. Nath, counsel for the respondent, matter stand referred. Listed again on 22nd
Lot.
of April. Twenty-second April.
So Lordship may kindly take it up on 27.
27.
7. Of August.
And then the
Tendency of the, that is not required, this is a contempt.
Then it's a contempt.
Lordship, here I have received the instruction in terms of court order 19th of March.
Reference to the earlier order dated 19/3/2026. Step 1, Agriculture Department is submitted before the court basis of instructions received. There was no order or approval in the finance committee. Respect of the writ petitioners to draw salary as per the 7th pay commission with respect to approval, the governing body of the Assam State Seats Certification Agency. Instructions are kept on. Counsel for the applicant with petitioner matter therefore stands referred. Listed again on 29th of April. Mr. R. Borokuzani appears for the finance department.
Yes, notice was issued, the other parties appearing.
I have entered appearance on behalf of the sole respondent, my lord. I'd like to file a short affidavit.
In review.
Review, my lord, this review petition is basically in the nature of a clarificatory petition, my lord, on facts.
It's for the review. When this is the review petition,
Yes, Lord.
then you are the,
I am the sole respondent, the lead petitioner, my lord. By this review application, my lord, some clarification has been sought for on facts, my lord. Let me file a short affidavit, my lord.
what now?
There is a little contradiction in two paragraphs, the direction part as well as one paragraph, the adjustment. We follow the final direction, then it conflicts with the observation.
Which paragraph?
13
13.
and 15. Paragraph 13, Lordship has come to a particular conclusion. Last three lines, since no such steps or any procedure was undertaken by the other, it has been held that till that time, the contract subsists and the petitioner is entitled to be paid all his dues in terms of the MOU. So Lordship has concluded that he is entitled for full dues. Then 15, the writ petition therefore is allowed to the extent that the respondent authority will examine the claims of the petitioner and release the amount payable to the petitioner in terms of the provisions of the MOU dated 24/1/2007, read with the award dated 11/7/1994 passed by the Industrial Tribunal, which stood upheld by the judgment dated so and so and passed in the writ appeal so and so. The impugn order dated so and so passed in this case by the Central Government Industrial Tribunal come Labor Court therefore stands modified to that extent. Writ petition stands allowed to that extent. The direction contained in this order shall be completed within 60 days from the date of receipt of the certified copy of this order. In the event any order passed is by the respondent authority, a copy thereof shall be served on the writ petitioner. In the event the respondent authority requires any particular documents from the petitioner, then the same shall be called for from the petitioner by giving adequate opportunity to place the same before the respondent. So Lordship has directed us to conduct a proper verification and giving in the opportunity. But if we do that and if something goes against him, then it will be in conflict of the last three lines of paragraph 30. So Lordship has already come to a conclusion in paragraph 30.
The contract subsists.
Yes, if we do verify, there should not be any break in service. He had taken leave for about 3 or 4 months. So if that break is there, then he is not entitled under the MOU.
How much time? Mr. Saiki.
If I may pay for a fixed date, my
File it, then mention it and fix it. Let the affidavit be filed.
Lord, highly authorized.
so
Better. My lord, the last occasion your lordship has asked the government to take instruction on the issue. My lord, there was the first round of litigation which we came before this court on the ground of transfer. Basically, this petitioner before this court is 2002 she joined Assam Medical College. Now thereafter she was a pediatric department. Then initially she was assistant professor, thereafter promoted to the associate professor. And she was sent on a sponsor by the government to Mumbai on a particular oncologist. He was the only oncologist
Assam Medical College. Now, 2026, she was transferred from Silchar, Assam Medical College to Silchar Medical College. Now, the respondent also was working in Assam Medical College. She was also transferred in 2025. She was also an associate professor. She was transferred to Silchar Medical College. In Silchar Medical College, this is one of the points, she was promoted to the post of professor under a scheme, DACP scheme. That scheme she was promoted. And she was getting the pay scale as like of a professor. Now, what has happened in the meantime? 2026, which is put to challenge before this honorable court, the first round of litigation, and the second is that she has been brought, who was promoted to the post of professor, she was brought back to Assam Medical College in the post of associate professor. So, your lordship of the first round of litigation was the case, it was shown before the court. On the first round of litigation, there was a representation which was pending before the court. And on the point of spouse. Now, the court said that your representation should be disposed of in accordance with law. Accordingly, they have taken a call on it. And if your lordship looks into their rejection order, please look into rejection order which has been put to challenge before this court. Rejection order, lordship will find at page 70. And my representation in pursuance to the court's order was filed at page 62. Now, please see, we have taken a specific point on the the spouse ground. Please see at page 70. This is the impugn order. See the second, whereas Dr. Jolly Rao was transferred, posted as so and so, whereas Jolly Rao filed a writ petition before the Honorable High Court, challenging the so and so, whereas the Honorable High Court by order dated dispose of the writ petition by permitting petitioner file a detailed repentance directing that the authorities will consider and pass appropriate order, whereas transfer and posting an official is an incident of government service and no individual official can claim the right to serve in particular place of posting as a matter of right as such decision falls within the realm of administrative agency. And whereas the government in the medical so and so has noted that the transfer was made as per administrative requirement, the request of cancellation of transfer has been considered that whereas no vacant post in Department of Pediatrics at the existing place of so and so. Now, my lord, this order has been challenged. Now, there your lordship has asked my learned friend whether there is some draft for what is the policy of the medical director of medical education, whether you have got some policy on. So he has to produce before the court. Then what is the policy of the government? Because there are other department, irrigation department, where there is a policy. Now, if your lordship looks into the policy, please see this one.
Draft.
Yes. Draft revised. Draft revised transfer policy, man. Draft revised transfer policy. Got it? Draft revised policy of so and
No,
so.
but this is in the, is it in the draft stage or has it been?
This is, suppose, let's say it is in the draft stage. Then what action can be taken? I have found one judgment of the Supreme Court. In absence of any draft service rule, or if there is an absence of any rule, then what will apply? TOPT will apply. Please see one judgment of the Supreme Court. This was discussed in detail. Please see the judgment of the Supreme Court. 2022, 12 SCC 1. Now it has been discussed from page para 10. My lord will kindly see para 10. B1, executive instruction issued by DOPT. So, from 1986 it evolved. 1986 they discuss about all the notification that has been issued by the DOPT. 1997 it has been discussed. Now please see para 10.7. Please see 10.7. By an OM, got you got it? By an OM dated 39/2009, their earlier guidelines were consolidated and was stipulated that when both spouses are in the central government or work in the same department, and if posts are available, they must invariably posted together. Para 5 of the OM stated, complaints are sometimes received that even if posts are available in the station of posting of the spouse, the administrative authority do not accommodate the employees, citing administrative reasons. In all such cases, the cadre controlling authority should strive to post the employees at the station of the spouse, and in case of inability to do so, specific reasons thereof may be communicated to the employee. Here, if you see the order of rejection, there is no specific reason, only on the ground of administrative reason. So, the point of argument is that if there is a draft service suit, my lord will look into it whether draft service suit is applicable or not. In absence of any rules, then this DOPT, it is my humble submission that this will be applicable. Because this is a DOPT man, it will be applicable.
See, it's a transfer matter.
Correct.
So, you, as a government servant,
Yes.
you're bound by your service contract.
Right.
That it's a transferable job. Unless you make out a case that you are transferred, be posted in a place where your status is lowered, salary is lowered, or you are put in a particular, you're given the responsibilities which you are otherwise not competent to handle, or the transfer is at the malicious reasons or grounds of some other person, the scope of interference is extremely limited, because we are not here to see how the administrative exigency is
But
satisfied.
what I find on the basis of judgment, there has to be some reasons for it. But I will give an answer to what your lordship immediately has said to me. Now, if your lordship, if it is lower in rank, it is not in that rank. Now, the private response number 6, which we have brought notice to the court by filing a small additional application. She was promoted. She was in Assam Medical College as associate professor. 2025, she was promoted. She was transferred to Silchar Medical College. 24th of February 2025, while she was serving as an associate professor, she was promoted to the post of professor.
So you're trying to project a case that she, for some reason, she wants to come to AMC, foregoing her promotion. But that is for her
See,
to
no. She has not foregone.
Ah.
This is foregoing her promotion. My lord, she was promoted there
Right.
in
Silchar.
Silchar Medical College as a professor under DSCP scheme. Now, she has been brought under what capacity? She has not been brought under
But
capacity.
that's for her to complain.
No, that's what. My lord, this is on. That's what I'm saying, not complain.
That she has been brought, that she has been working as a professor and has been brought to another place in the capacity of an associate professor. Is the ground for her to check.
No, what I'm saying, she takes my place. That's what DC can't do it. Absolutely no problem. You remain in Dibrugarh Medical College. Absolutely. So don't take my place. It is my cadre. One second.
Your place, please.
My place, my holding the post in Assam Medical College is associate professor. She has been brought. She was promoted at Silchar Medical College, 24th of February 2025. She worked there in a vacant post. She got promoted, maybe on a regular or under the scheme. Again, she has been brought to Assam Medical College in my cadre, associate professor. That's what my complaint is. My complaint is, yes, you remain in Assam Medical College, not in my cadre. You be a professor.
No, but how does it affect you?
No, my post, she has taken my post. That's the associate professor post. That's what I'm agreeing.
No, but you are transferred in the capacity of an associate professor.
Maybe, but you have been brought as what? No, my point is that My lord, you have been brought as what? You have been, I am putting a question myself.
But that will be lowering her capacity.
No,
her position.
My lord, that is absolutely, you have been promoted, you have been brought, but why not in the same post as a post of professor? Why you are taking my post?
It's for her to complain.
But now this is,
Not that
my lord,
transferred,
my lord,
from
please see.
diploma to Silchar.
No, I will show one notification in DAC. What is the notification? How it should be done? Please see that dynamic assured career progress. That's what medical education. See, my lord. Now, if your lordship looks into 3.7, please see 3.7.
Yes.
In due course, with generation of vacant position, the faculty members who were promoted under DACP scheme in their same institution shall be incorporated into direct vacant position across the medical college Assam as per hierarchy in the gradation list. Now please see structure of DACP. 3.7 kindly see, my lord. Now, what is the ground of bringing to the post of my post which I am holding associate?
No, we are not understanding. See, your service conditions as an associate professor
Yes.
remains intact, whether or not the private respondent is
No,
brought
I
here
am
or kept there, except for the fact that you are now being transferred to a different medical college. So it is a question of, essentially a question of transfer. Now, if it is a case that no, there is no faculty or department in Silchar Medical College of your expertise, and you have been transferred only to accommodate the private respondent, yes, you certainly have a case. But if it
there are minor 2 points which I have raised. But minor 2 points of which I have raised before this point. First point which I have raised is about the spouse. That's the main point which I have raised. And in that case, your lordship has given a direction to consider. Now, administrative excessivency is on the base. Now, your lordship has to look into whether there is the draft service rule has been made by the government or not.
that is what they are
That
supposed
number
to.
one. This is what your lordship has indicated. Now, if your lordship finds, we go to the order that has been passed by this court.
Right.
First point. Now, please see the draft service rule. If you see draft revised,
Transfer policy.
yes.
This private respondent is a specialist in what?
Well, she is not oncologist, she is a pediatrician. Like me, but she is not specialized in oncologist, which the government, why not, it has been sponsored. The government said I went to Tata Institute and I have specialized in oncologist. Now, let's see my lord draft transfer for your lordship got it. Now, if your lordship like, see at 6. 6.
6. Yes.
If the husband, lordship got it,
6. Draft transfer policy.
of teaching faculty, doctors of government medical, that is page number 1, 2, 3, 4, number 4.
So we have only 2 pages.
Lordship got it?
You are referring to the minutes of the meeting.
Yes, yes. Minus or lordship got it?
Yes.
27, and please turn to
Point number 6.
not this. 1, 2. Next draft transfer policy.
Yes.
Draft transfer policy of PC. You also got it. Now please see 6, 9. 6. Next page 6. If the husband and wife, what you got it? Both are in the service of Assam government, efforts will be made to locate them as near as possible. Preference would be given to the one serving in the health department. Now both, my lord, the husband is working in the Assam Medical College. He is a doctor. So this orthopedic department, and I'm in pediatric department. So if this is, I don't know whether the draft policy, what they want to say on draft policy of teaching faculty of their department, I don't know. My learned friend will be able to tell the court that what about this? And what my argument was that your lordship has given a direction. Please see the direction of this court.
According to you, this aspect of spouse posting has not been dealt with
That's what I am
by
saying.
the authority.
By the authority. And second, my lord, the respondent, private husband, is a businessman. He is not a doctor. I could have understood. He is a businessman. My husband is a doctor, same medical college. You have not dealt with. No reasons has been given. But my repent, your lordship direction, please look into it. What's the High Court's order? My lord, kindly see High Court's order at page 58, 9/3/2026.
Yes. Paragraph
Yes, paragraph
7.
Yes. Consider submission made. This court is a view for the that ends of justice made in the petitioner permitted liberty to file a detailed report ventilating of grievances before the competent authority, namely the commissioner, so and so. If such an applicant files in 2 days from today, same shall be considered by the concerned and thereafter pass seeking order. According so some protection was given, so it shall not be given to transfer order at paragraph 10. Now with the authorities concerned thereafter pass a speaking order. Lordship got it? Speaking order. Now, my lord, we represented the matter before the government at page 62. See page 62. Representation was filed in pursuant to court's order. Now, the paragraph 9C, my lord, page 65. Paragraph 9, page 65. See, para 9. The lordship got it? That the applicant state her husband, namely so and so, has also been working at so and so. Hence, for smooth discharge, consider spouse posting policy. A posting in Assam Medical College and Hospital Dibrugarh may kindly be considered. Government has been regularly following the state spouse posting policy, whereby efforts are made to the post spouses at the same station, particularly in the case of medical professionals, so that they can discharge their duties most effectively. So this basically the point which you have been raised, and in what manner they have, my lord, taken the at page 70. This is speaking order, my lord. Pass a speaking order. You don't pass a speaking order. Why this policy? We are rejecting your policy on this ground. Only on the ground that administrative reason. The court, the honorable court has passed an order, give a reasons order. I could have very well understood that if order was not there. I filed a representation in pursuant to court's order. Representation has been filed. Specific point has been taken. How you dealt it, page 70, my lord. Kindly see 1111 paragraph, my lord, they decided. And there has to be some speaking order, my lord. That's what the judgment of the Supreme Court is said, my lord. Kindly see, my lord. Speaking order. Kindly see the judgment once again at 10.5, my lord. 10.7. See the judgment of Supreme Court which I want to connect it. See 10.7, my lord. There is a circular, DOPT circular. See, my
But
lord.
this circular, whether it is has been published.
Department of Personal, man. This is a central government circular.
Whether
Time
central
to
government
time.
circular are not ipso facto binding on the state. Whether a similar circular is available in the state government.
State
If yes,
government.
then yes, the
I.
information will be issued.
Some department, irrigation department has got. Some department has got. Please see this, my lord. Already you handed over. Already handed over. See the irrigation department. See the irrigation department. Paragraph 5, my lord, of irrigation department. See this one. Paragraph.
Paragraph.
6 mile, 5 or 6. Got it? Paragraph 5. If the spouse of any officer of the department is also a government employee, is a transferable post, and the spouse is not immediate due to for transfer, then the officer may be posted in the same headquarters as that of spouse or in a nearby headquarters as far as that.
What is the government?
Now please see one of the circular which we are guided by that. NMC, my lord, National Medical Commission, my lord. Please see this, I am giving a my lord, see it true, my lord. Once a faculty of for one academic year has been counted, not you got it?
Yes.
In a medical college, the same faculty cannot be accepted as a faculty of another medical college the same academic year. A faculty is required to make a declaration to this effect. This is what I was in teaching line or entering teaching line. So how can they violate this? This is also one of the violations. Ground is that response number 6 anyhow has to be done. For time being, it has been sent 2025 and all they were promoted and thereafter again he was brought. Now, how they dealt, my lord, will kindly see how they dealt with the representation that has been filed by us in pursuance to the order that has been passed by the court. There is no reason. That is what the Supreme Court has said. Even maybe an administrative ground, but there has to be some reason. So, how they have dealt?
You are a faculty member.
Yes, I am a faculty member.
In which department?
Pediatric department. I am a faculty member. This is also a violation. National Medical Commission. This is the year
23.
third year. Here I will show you. See. See, my lord,
Why
one
have you
to
not
academic
brought it by
calendar
way
of
on record? These are relevant. If you are filing writ petition, additional affidavit, you should have brought it on record.
we have cited in the edition. We have stated that.
Right, this is 25.
25, 26. Yes. When 2020, third column, kindly see. Third column,
Yes.
2023 back. So you find PD, pediatrics. Second column, CM, FM, EN, OP, MD,
No,
surgery, OG and PD.
For which year?
For year 23 batch.
23 batch.
Yes. Academic is 2025-26 on the top. Academic is 2025-26. And say
Where
August
is- where is-
2026 the exam.
Where is pediatrician?
Yes,
Pediat-
PD. Yes. August 2000 university exam is August 2026. Kindly see. 2020 still it is there. This is the case.
Yes, Mr. Bora.
My lord,
regarding the spouse policy, my lord, as my lord, the petitioner has represented in page 65, my lord. It is their statement only, but they have not imposed any policy, or in our department also there is no such policy, spouse policy, and that's why, my lord, it has not been dealt in the speaking order, my lord. It is mere a statement that is spouse policy, but in our department, my lord, MERD department, there is no such policy.
But if the policies are issued by the personal department,
If it is issued by the personnel department, my lord, that's why our MERD department has communicated to the personnel department whether there is any policy. So, my lord, if we receive, my lord, then the department.
there,
UPT, it is central
not
government.
DOPT, personal department transfer policy. That policy where it has a person should not be transferred beyond without completing 3 years, then that got amended to 2 years.
Yes, my lord.
It is in that policy.
My lord, that's why on the basis of your lordship's direction, my lord, I have sought for the instruction from the department. But otherwise, my lord, as of today, while considering the representation, my lord, no such policy was before the authority to consider, my lord. And that's why, my lord, in the representation, in the speaking order, that aspect has not been considered. That aspect has not been dealt with, my lord. If any such policy would have been enclosed by the
But if we
petitioner,
are not dealing with it, how do we presume that there is no policy?
it is not presumption. If it is not there with the department, that is on the
The
basis.
department has to say that as on date, there is no policy available in the department with regard to spouse posting.
My lord,
That is not available. That is not there.
whatever materials were available before the authority, before passing the order, my lord.
This is the clarification of the order passed.
Yes, my lord.
The reading of the order does not reflect that
My
that
lord.
aspect was considered.
Yes, my lord. Because
You are
if
only-
they
you
would
are
have,
now-
they would have
you are now
supplied any,
clarifying.
they would have supplied any policy, my lord, along with
Why
the,
will they supply?
because it is their case, my lord.
So, but
They
you
are contending it, my lord.
are the department, you
Yes, my
say
lord.
whether any policy
They
is
are
there or not.
contending something is there regarding that material. They have to supply, my lord. Then the department will
What kind
consider,
of
my lord.
submission are you making, Mr. Stepping Council?
My lord.
We
as
are
of-
asking you whether in your department, are your authorities aware that there is a transfer policy with regard to posting or not? The answer has to be yes or no.
No, my lord.
It can't be that no, it depends on where. What
That is no, my
information
lord.
comes from the
The
petitioner.
telephonic instruction I have received, it is no,
But-
and that's why they are.
But what we are saying
They-
what we are saying is that answer is not discernible from the order. It should have been. You could have, your authorities could have said that there is no,
My
at
lord,
present there is no policy.
Now, my lord, our department is communicating with the personnel department, my lord,
Ah.
whether any such policy is there.
So
of the
therefore,
person-
you don't know as on date whether it is there or not.
Yes, from personnel department, we don't know. Because they have not replied yet, my
Now,
lord.
with regard to the National Medical Commission, what do you have to say?
My lord, I am not aware of that contention because I
Ah.
don't have any document, my lord. Now only what they have stated or what they have contending, my lord, I don't have any, my lord.
You
In the-
you give him a copy.
In the affidavit also, no, in the affidavit, that aspect has not been dealt with, my lord.
I have dealt, this is paragraph 9. Paragraph 9. Page 76. Paragraph 9.
Paragraph 9. No, it is not NMC, my lord.
So it is not
Paragraph
a nine. Error 9.
Para
Yes,
9.
ma'am. It is not NMC guideline.
Yes.
Mechanism.
It is stated in the midst of the academic year, the transfer of faculty of one medical course to another is all disposed by the National Medical Commission. This we have discussed.
Yes, my lord. Each affidavit we have received, I have received just 1 hour back, my lord. And what is the circular, my lord? That circular I have not seen, my lord.
So, okay,
So regarding this,
Get instruction. But Mr. Didas, the senior counsel assistant. Receiving the 7-3. 6. there is also the transfer order. Where is the transfer order?
Transfer order is at page 27.
Transfer order.
27.
I think State Professor AMCHLD is transferred and posted as Associate Professor. Private respondent was private respondent has relieved the petition. It's a posting. According to the Associate Professor in the Department of Pediatrics has special training and exposure. Sphere of pediatric is that by some medical say substantial number of patients who are undergoing say treatment with pediatric so submitted the transfer patients undergoing treatment under pediatric. Private respondent is private respondent according to the petition of such treatment. Submit that petitioner's husband so serving as in some medical college. In which department?
Orthopedic.
Surgery department.
Surgery.
Orthopedics. Therefore, since spouses are serving some medical college hospital, as per the draft policy adopted by the as per a policy adopted by the respondent authority, decided that spouses working under the department are same places of posting as far as practical. Circumstances by filing WPC 175 of 26, which came to be disposed of the direction 936, thereby petition state resolution possible speaking. Seat of the application file. Yes. Permitted by the file. Six, disposed of. Decision. Respect of the transfer order dated 28. And that these may be considered serious for administrative aid. Very last date, the respondent counsel was permitted to take the instructions in fine the counsel needs to option of an additional 11 by 6th of April 2026. Statements in the affidavit to the effect that there is a draft policy which has been adopted by the department with respect of transfers and posting with regard to health department. So there is also a categorical error that transfer of faculty member, one medical college to another. Circular issued by the national medical commission dated 28. Circular is see that instructions to all department states same department. Further provided, further stated therein that submitted on behalf of the recipient that this status of a professor. Private respondent. Respondent would not have replaced Bishop. Some medical. What are the other end? Subjects. Instruction that the medical department, medical research department, medical research,
Medical education.
education research department. There is no policy with regard to transfer and posting that spouses being posted at the same stations. So, however, see exists. See, personal department government, whether such policy will be binding. Like circumstances at the state, considering the fact that private respondent will also relate to the part. Say, should this stop that? Search the part. High speed. Capacity, through the history of the affected to dusty, that are happening binds to the effect by the and transfer the respect of the petitioner vis-a-vis private respondent.
Private respondent has already joined, around 1 month back, my lord.
Like respect of the second.
But the issue will remain because there is no vacancy of associate professor in the NCH.
I have not.
Because the private respondent has joined, my lord, long back. Long back, my
Or
lord.
if you want to get instructions by Wednesday, get it.
Yes, my lord.
But,
By Wednesday, on this issue, my lord, on the NMC guideline, because the issue of associate professor is not there.
we'll have to decide this issue.
Yes, my lord.
Let us be on 22nd.
Yes,
I'm sorry.
22nd of April.
Yes. No, let me order
My lord,
because
my
we have
lord,
made a statement.
We are giving even interim protection that shall not be given effect.
Correct.
So far as
My lord,
Right.
regarding the NMC guideline, I can take have the instruction. Your lord.
or you bring it on record because you can't decide issues like this. It has to be decided finally whether these, number one, whether there is any policy with regard to spouse. Number two, whether the NMC guidelines will have an effect.
My lord, NMC guidelines, what NMC guidelines say? NMC guidelines, what is the purpose of this? The board has also noticed that various writ petitions are being filed in various high courts by faculties who have been transferred by the state government from one medical college to another, alleging that their transfer will result in deficiency in the first medical college. So what is the purpose? So now another person has been replaced. So there is no question of deficiency in the earlier medical college. So this is the purpose of this NMC guideline, my lord. It is a guideline, my lord. It is not meant because otherwise also prima facie, my lord. What these guidelines says, because once the one faculty member is transferred, normally in the
Court considers necessary to pass during soon, right? Same station. Second meeting.
I'm like,
But my lord, there will be difficult regarding the posting, my lord, because the other person
Yes,
has
sir.
already joined. It will be the administrative problem, my
I
lord.
not see my certificate in the
It
IA.
is,
Because
it
the
is up
other,
to the petitioner to decide.
Yes.
If the person has already joined,
yes, my lord, it is
Yeah.
on record. He has joined, my lord.
then Mr. Das,
No, see, join what? My lord, kindly see as a professor DSCP. Kindly see, that's what the
My lord,
holding 82.
that point I want to
82.
clarify, my lord. What is
82.
Professor
where is the
DSCP?
joining letter?
My,
Where
I'm
is,
sorry.
you have the joining letter.
What is Professor DSCP, my lord? That point I want to clarify. My lord, the Professor DSCP, that person is holding the substantive post of Associate Professor. Because, my lord, Professor post is not available, my lord. That's why under
My
that
lord, let
particular scheme, my
the
lord.
matter come on 22nd. We'll see if that order, if it is not given effect, yes, I'll suffer. If she has joined, she has joined. So your lordship
Yes.
will indicate it.
Yes, my lord.
My lord.
That your lordship may
No, what it
observe.
is indicated, what
It is
observe, because
not
they
required to be
indicated.
clarified.
Yes,
Said not to be given effect.
yes.
So if the other person has joined,
Yes,
it's up to them to
Yes,
decide
we'll see it.
Yes,
their
sir.
conditions of service,
Yes.
etc.
I'm
But
deeply
that you must be aware of.
Yes,
We are
yes.
putting you to notice.
No, that's what I'm saying, my lord.
Because
This is-
you are transferred from place A to place B. And somebody else has joined in place.
No, I have not given, the charge also, man. How it can be minor? That's why I'm making a statement not to give effect. Yes.
If you are considered.
Next statement. Deeply obvious.
there's lordship,
We had fixed some matters, I think. You are coming
No, this is
different.
dismissal from service.
dismissal.
Yes, sir.
They have been dismissed proxy after serving 2 years after confirmation.
Have you filed your appeals and all?
No, it's not.
Then
Because they have not followed the any procedure and lordship from prima facie from the order it's which that the order has been lordship passed lordship.
where is the new order?
Yes, lordship. That lordship may come to this 51. And for swing the implementary paragraph 2. And
Let them get instructions here.
He said to go.
lordship that here the prima facie they are saying that in terms of clause 6.4 and 6.5, the petitioner they did not fulfill that those criteria of the product. Whereas lordship, I have annexed those documents also that petitioner has lordship submitted at the time of the recruitment process. He has
We will
submitted.
examine it. It's a termination matter.
Lordship, may I read that that termination order may not be given effect.
It was passed on.
Passed
which
on
date?
8
Yes,
January.
January. Then
January.
immediately we have
Yes,
come.
sir.
Huh?
Operation may be stayed.
Well, how can it be stayed?
8
What
January.
will be the effect? You will be deemed to be in service.
Lordship.
How can it? Right, how can the party choose? CBC. And it's in
Online. Last order, instruction is negative. Otherwise, matter is limiting to pensionary benefit to the daughter of the original pension. Some only minor clarifications are required from the treasury office. 87.
Yes, lordship, here we have written to the AG law. Lordship, I have sent one communication
Your Lordship, we have written to the AG because both the PPOs have been misplaced, Lordship. One half of the PPO was with the bank that has been misplaced, and the other one has been misplaced by the petitioner. So now,
AG, it's for AG, Accountant General. For Accountant General. Yes, Mr. C. Barua, Mr. Barua, A. Barua, please get your instructions.
well, on 20th of March only we have written, Lordship. I'll share the communication. I have just given the
Give him my comment, give him the copy.
Lordship.
Let them get the instructions. Wait immediately after 22nd. 22nd of April.
Gotcha.
Matter be listed again on 22nd. Office of the Council for the Accountant General and Finance Department to complete their instructions in the matter.
Lordship, will be the AG. AG will have to pay.
AG, Accountant.
If it is law, then reconstruction can be done also by them. And matter may be
In
listed
the
in the
event, they instruct the Standing Council, Accountant General, apprise the court as to the steps required to be taken. Reconstruction of the
Lordship, the letter.
office of the PPU is placed on post. Respect of the communication.
Yes, Lord.
On 22nd.
No, it's not dated 2006 number. The
No ID
notice
card.
was issued to the consumer by the speed post. And that means they no AD or answer notice. Also personally served notice also. By,
By Dusty.
by this speed post from the office. Personally, I have also.
You're personally giving has to be by way of Dusty. You want to take Dusty, you take the registry of the court.
It's just sent by the speed post.
So the office note reflects the AD card has not been received. So we'll wait for her receipt for completion of service report. As per office note dated 1/4/26, the AD card on Mrs. Served has not been received. Matter stands referred to be listed after weeks. Ministry to verify the service of notice, make necessary endorsements.
All right.
Item 59, we have filed the interlocutory application seeking modification of the order date 4/2024. Lordship will find the order at annexure 1, page 11. So while issuing notice in the matter, this Lordship has directed us not to proceed with the departmental proceeding. Kindly come to page 12, order date 4/2024. The relevant portion, at page 13, last panel, Lordship has said that having heard the learned counsel for the parties and upon careful perusal of the pleadings on records as well as the judgment cited at the bar, it is seen that the FIR itself also reveals that the allegation made are one and the same. While there is no bar as per law laid down by the Apex Code for simultaneous continuation of the departmental proceeding and criminal proceeding, it is seen that at this stage the criminal proceeding are still at this stage of investigation and no charge sheet has yet been filed. The learned additional so-and-so is also not posted with the instructions as to the status of the criminal investigation. The list of witnesses and the documents which are referred to in the show cause notice also prima facie appears to be connected with the criminal investigation, which is being carried on at present by the investigating authorities. Perusal of the suspension order dated 1/12/2023 shows that the petitioner was placed on the suspension pursuant to his arrest in connection with PS case number 353 of 2023 under section so and so and pending departmental inquiry. Under such circumstances, prima facie, it appears that to the court that the disciplinary proceedings are initiated on the basis of materials available for the investigating officer, as the investigation is still underway and no charge sheet has yet been filed, and also as it prima facie appears to the court that the materials relied upon by the disciplinary proceeding and the investigations carried on by the investigating authority related to and arise out of the same incident, it is not possible to arrive at a conclusion at this stage that simultaneous proceedings are not going to be beneficial to the petitioner. Under such circumstances, since no show cause notice has been served on the petitioner, although the departmental proceeding has been initiated, the departmental proceedings shall not be proceeded without leave of the honorable court till the next returnable date. It is made clear that the authorities are at liberty to complete their investigation and to take it to logical end as expeditiously as possible. The further continuation of the interim order will be decided on the next returnable. But here, the investigation is complete. Already charge sheet has been filed against 10 persons including the petitioner. But in fact, the order impugned is only a decision of the authority that we will sit against the petitioner departmental. No show cause has been issued. The projection has been made by the petitioner that the charges in the show cause and the criminal proceeding are same and the witnesses documents are same. In fact, what has happened in para 8 of our IA, we have said, kindly come to para 8. Till that no show cause notice has been issued in the disciplinary proceeding, although in the petition, the petitioner has made a projection that disciplinary proceeding is going on against him. It is only a decision of the authority that we will proceed departmentally against the petitioner. And the applicant said that the opposite party number 1 will be provided all necessary documents along with the charges which show cause notice will be issued as per law. So there is no bar for the authority to go ahead departmentally while a criminal case is pending. At that stage, Lordship has passed the order that since the charge sheet has not been filed in the criminal case, we are asked not to proceed at that stage. Now, we have sought for modification of the order because now the charge sheet has been filed. The charge sheet has been filed against the petitioner. And the departmental authority, as per the law laid down, we have relied on 2-3 cases of the scope. The law is very clear. Simultaneously, departmental proceeding as well as the criminal proceeding. What can go?
The order itself.
No. So that clarification is required. So Lordship has directed that, and in fact, Lordship has also observed that in that particular day, no show cause was issued to the petitioner. And kindly see, in this IA, they have filed a reply. In para 8,
The IA.
reply to our IA. What they have said, kindly reply they have filed on 22nd of March 2625. I'm reading what they have said.
You may be reading, but it is not here.
Otherwise, the issue, it is pending before division bench of this honorable court.
No, that is
I will come, my lord.
that is a different
question,
case.
My question is this, my lord, whether on the same facts and my lord documents, a departmental proceeding as well as my lord criminal proceeding will go together or not.
Not an absolute bar.
Not bar, but my lord, if it causes prejudice, I have been compelled to disclose my defense, my lord.
No, we have not issued the show cause till date. Where is the question of prejudice?
Second one.
No show cause. In against this
That's
petitioner,
reply, you file your reply.
Reply.
Not here.
against the
Let me
petitioner.
reply now.
What?
But in
What
fact,
is your prayer now? You
My
want to
prayer-
proceed
My
departmentally.
prayer is to Lordship may allow the authority to the authority to proceed departmentally. That is what.
What
Now
I'm
it
saying,
will
my
be-
lord,
it will
let the,
be prejudice.
my lord, let the all, both the matter, because both the matter are connected, my lord. Let the both the matter be heard finally, your lordship. And my lord, in place of,
In the order itself,
my lord,
there is a finding that no charge sheet has been issued.
But my lord-
In the proceedings.
my lord, but in their affidavit in opposition, they are saying it is based on that criminal case.
Maybe, but departmental proceeding will initiated upon issuance of charge sheet.
My
Your
lord, but,
ground,
but my
your case is that you will be prejudiced once the departmental proceedings.
my
are
lord, my
initiated.
lord, my lord. But my lord,
So far is
page 19 of my petition, your lordship.
Which petition?
My petition,
Writ
17, writ petition. Page 19. And subsequent order. So and so were attached with the police commissioner at Gauhati to undergo prohibition sub-inspector has been arrested in so and so. Pending drawal of departmental proceeding. SI so and so is placed under suspension from service with immediate effect so and so. He will so and so. Thereafter, my lord, page 20. Whereas considering the grave nature of charge sheets against so and so, and based on the recommendation of review committee, they are saying, my lord, but it was not communicated. Thereafter,
So are the department, are the supposed to be issued?
my lord, initially it was, my lord.
No, page 24 is the impugn. Kindly come to page 24 of the writ petition. That is impugn in the writ petition.
Drawn up, yes, page 20.
This is our decision that we will draw up a
But the charge sheets, charge memos are not issued.
True, my lord, but they are saying a departmental proceeding by so and so is drawn up against so and so for his gross misconduct.
Where is the bar that it cannot be done?
I'm not on that. What I'm saying, your lordship, two petitioners, my lord, in connection of one Bharlum police station, my lord, they have been apprehended by police. I was assisting IO, your lordship, and against IO and me, my lord, proceeding has been initiated. So what we have submitted before, both the matters are connected, my lord. I have been placed under suspension. Thereafter, departmental proceeding. Although, my lord, I have not received so notice, but as per page 24, it has been drawn up. The question is, my lord, whether, my lord, because in connection of Bharlum police station, your lordship, criminal proceeding is also going on, my lord. On the same facts, on my lord, in the second one, your lordship will see
No, I have
1694. Both the matters are connected, my lord.
No, on the same facts or not will be evident from the charges which are framed against
My lord,
you.
in the second, they have issued charge sheet and everything. Second one. On the writ petition number 1694.
We'll keep it up for admission,
My lord.
hearing.
But Lordship, I have prayed for the Honorable Court sitting Gauhati. Kindly see his prayer at page number 40. Impugn is 17 to 2024. That is our decision that we will go proceed departmentally, and his entire case is that if we proceed departmentally, it will cause him prejudice. Lordship has directed that since investigation charge sheet has not been submitted, you wait for some. Now charge sheet is filed, and no show cause has been issued till there.
Where is the charge sheet? Here?
The charge sheet we have not annexed, but we have stated in the eye that charge sheet has now been filed.
My lord, page
In-
26 of
in
second
para
writ
eight.
petition.
Let me submit.
Right.
In the second writ, you have issued show cause.
But in that I have not, we have not filed I.
In connection of both the, my page 26.
That may be, but he cannot, well, this petition has to be.
There is a reference of present writ petitioner, my lord, in second so forth.
Whatever it may be, but in respect of the first writ petition, whether any.
But I have been suspended on the basis of my lord Bharlum station case number one, and my lord, disciplinary proceeding had been initiated, drawn up against me.
No, so
In
Where
the,
is the show cause?
my lord, but
So
in the
where is
order,
it?
your lordship, page 24 has seen, your lord.
Para 5 of our I.
And page 26 of second one, my lord, they have specifically mentioned about me.
We are asking you about the first item,
No, my lord.
charge sheet.
No, they have not.
So at least authority can issue the show cause. In 2024, when we issued the order on 17th of February 2024, he approached the Honorable Court. And in paragraph 5 of our I, we have said that now the investigation is complete.
Bring it on record, bring your objection
Right.
on record.
No, Lordship.
Let us hear it on 20, 0,
Lordship.
0 April.
Lordship.
It is submitted. That party is filing objections. I number 20. Verify the same. Connect the taken to be filed with our department/petition. State again.
Can it be on
On-
22nd?
on- on-
20?
Let it be on 20.
20.
Lordship.
Deep log.
Our respective clients, are co-wives. Our husband had died, and thereafter the
How
bank.
many wives? 4 wives.
No, we are co-wives.
Three wives.
We are co.
You have agreed on something.
Yes. That
Right.
affidavit we filed, paragraph E, that is. Lordship finds paragraph 4, page 118.
Yes.
Pampa Das and Sikta Das are two wives, and Sonjukta Das is the daughter of the earlier one, the first one. She is the one. This is the agreement.
You are agreed
Yes.
in terms of this
Yes.
affidavit.
More particularly, clause, paragraph E4,
He would be the family pension.
family pension.
May I try one thing? Something that my senior colleague would say.
Why have you filed a joint affidavit?
Oh, why?
Because the matter has been.
Otherwise, the apportionment would lead to a dispute necessarily. Therefore, we have filed together.
Yes.
The amount lying in the account of the deceased, that may be disbursed at the earliest. They are
Who
very
is
poor.
the senior amongst in terms of marriage?
Is it very checkered history?
And
I would come in.
Apparently appears to be his.
Have you stated this in your affidavit?
No, we have stated this here, but so far as the nomination in the pension account goes, perhaps it's in her name. So therefore, we have agreed on papers.
What are the what is the agreement?
Agreement, yes. Number one, we say whatever amount would be lying in the bank account of our husband in the Punjab National Bank, that 50% would go to the respondent number 7, Shikta Das, and the remaining 50% will be apportioned between the two petitioners, mother and daughter, 25%. So far as the family amount pension is concerned, entire thing would be credited to the amount to the account of Shikta Das every month, and on the same date she agrees to credit 25% to us, failing which we have the liberty to approach the bank to keep on hold the release of the family pension until further orders are passed by this court.
Who's for the bank?
Bank,
Get
we have
the
served copies of the bank.
Huh?
We have not noticed, we are waiting for the council.
Who's the counsel?
After,
Mr. Parvez.
after-
Always after.
the bank would not have an objection to our common understanding.
May not be, but bring the counsel since they're here.
Correct.
Bring him.
At 2.
Termination matter, directly to file the affidavit. But they say because of the election and all, that report from the district is awaited from further time.
Mr. B. Gowai is taking state. It is prayer for the time. Nine? Okay, good.
Public.
Here in this matter, Lordship, I filed my affidavit this morning. Lordship.
Your Lordship, we have received it of 11:55, Your Lordship. We will not file our counter, Your Lordship.
May not be, but it needs to be brought on record. Mr. D. Woman, that's something else, some. Affidavit of department, fine. Today. Yes, sir. There will be course of the day, copies. They will be served on the council. So the affidavit statement, fine. Is the matter again on 29th April. Thanks. 29th April.
Receive affidavit in opposition from respondent for 23 today.
Counsel for the petitioner submits that affidavit in opposition. File and copies thereof. See. Respondents, filed by respondent number 2 and 3. Counsel for the petitioner therefore submits that they would like to file a rejoinder. 6 2 weeks time. Mr. Arbor Pujari, finance.
Finance minor.
MS so for we have a market. This matter again. 8th of May.
Finance and accountant general have filed our affidavits today, minor.
We have recorded.
Right. And so,
मला मुद्दा देतात मला 33 मला और 303 मला
Yes,
Finance
who's
department
supposed to
madam.
get finance?
फायनान्स मला
Yes, finance department.
पूजारी मला
Yes, Mr. Borpujari. Why the amount has not been released?
कोपराचा पेजार
we have taken up the matter with Treasury officer, minor. He says, minor, some infirmities are there, minor. He is seeking for some further time, minor.
Time.
Further time.
Mr. Arbor Pujari, hearing the finance department. That verifications are sought for. So,
Kopradar.
Kopradar,
minor.
waiting. Brings for the time. Mr. K. Sorry for C. Mr. Arbor.
सरिका जो
Study to government.
कोपराचा पेजार
They are also
if it is under preparation, I am seeking one more opportunity to file it.
yes.
Mr. T. Devi, who the petition, Mr. Rai Gota. Please. petitioner.
Very good.
This material of state respondents, the department is supposed to take it here. First order dated 1/12/2025.
What did it prevent here?
Here, your lordship, I have challenged the inquiry report, your lordship, and the punishment order, your lordship. Here, in this instant matter, your lordship, the presenting officer at the time of the inquiry itself, your lordship, on that particular day itself, had relied upon certain documents and which were furnished to the inquiry officer, and those documents were never given a show cause to me, your lordship, to reply or to put the defense. And furthermore, your lordship, in this instant case as well, I had followed the orders of my superior officer. If I had not followed the orders of my superior officer, I would be put under the cause of insubordination. And furthermore, on the similar set of charges, your lordship, the other delinquent officers had been, your lordship, exonerated, while on the other hand, I had been made to undergo the punishment of stoppage of one increment without cumulative effect.
Here, Mr. Godam,
Instructions are awaited, ma'am.
Mr. D.S.
Yes, sir. Much obliged, your lordship. Okay.
Mr. J. Patwari, appears for the prisoner. Finance Department is granted 2 weeks for the time file their affidavit, telling which court will proceed to hear the matter on the basis of the schedule of the court.
Finance taxation.
Finance taxation. Submitted by Mr. J. Patwari. Supreme Court.
Has been dismissed.
Huh?
The review petition has been rejected.
Rejected.
It has been rejected. I need 1 week's time. I'll try and advise him.
It's pending. So, maybe partner with you, something that time. Date will update with instructions. This matter immediately after 2 weeks. 6th of May. Biblium.
I have received instruction, lordship, I want to sign it.
State.
Lordship, all respect.
Hearing for the state submits that instructions have been received. They require 3 weeks time to file their act. Prayer may be not objected to any counsel. 3 weeks. Prayer.
Since the petitioner has been promoted to the post of lordship works as sectional assistant lordship, On the basis of the approval received from the lordship will file at page number 21.
Petitioner submits that the petitioner superannuate in May,
Yes, sir.
which 31st,
31st of May.
31st of May 2026. MS Shori appears on behalf of Mr. J. State the respondent expected to yes. Mr. I. Boda, HED.
High level.
Instruction is awaited not to order teams timing. The matter pertains to dismissal from service.
Dismissal from service. He should issue rule and call for all the record. What instruction will you give us?
Where I was coming here to receive.
Receive?
No,
It's not receive.
not received. Awaited.
When was the order of dismissal passed?
On 24 minutes, 2011, 2020.
Council for the states renews his prayer for completing the instructions. He prays for 3 weeks for the time. So, dismiss from service and therefore this matter on 14th.
Much of it.
So he is the sector officer,
Yes.
not covered. This is your instruction.
Yes.
Have you shown it to Mr. Sukhia?
Sure.
That is the ECI interpretation.
Departmental council is also there, madam. Corporation department has passed the order.
I have taken instructions. But it does not order that
Reconsider that. Pass appropriate order.
In the whole, the regarding Food District, Election Commission has the notification is there. I think page 29. Here also stated 23rd December 2008. The Election Commission of India, by the instruction referred to above, had directed that the detailed review shall be undertaken before every election in all districts, and all such officers should be posted out of their post. Whether election, they are not appointed. And even though appointed, they can be worked in another district as a zonal officer.
From where are you saying that?
No, I asked about telephone secretary. Then down there, but they can do it. That's why it should go there.
With all respect, my lord, order has been passed by the Cooperation Department. Competent authority is the Election of Commission of India, my lord. Secretary, my lord, they have nothing, to do, my lord.
Cooperation department, I asked the secretary cooperation department.
Secretary Cooperation Department
But
standing council is
Cooperation
submitting,
Department,
my
where
lord, they have the written instruction.
Cooperation department, there is the standing council.
He is appearing and he is submitting that.
What are your written instructions? Why are you holding on to it? When was the transfer order issued?
My lord, that's
15.3, your sector appointment is after the order of transfer.
no, my lord. Before that, that is why I have lordship asked an order to file an additional affidavit to bring on record. And I have bring on record, my lordship, kindly see page 44. This is an order of 21-2, my lord. This was, my lord, subsequently, my lord, this was modified. Page 44 of my additional affidavit.
4 of you?
Additional affidavit. Pursuant to lordship last order, my lord, I have filed the additional.
44.
Lordship. The type copy, original copy at page 44, 46, my lord. Thereafter, it is modified. District election officer has passed the order.
Detail করে দেন, detail কই? Detail করে মানে যত কিন্তু এখানে appointed.
Then in the petition, my lord, subsequently it was modified.
Where is the order in the writ petition?
Also. That is not in page 34, annexer 4. That case 21-2-2026 order was referred above, and then my lord, name appear in the top page 35. As sector officer. Reference of order dated 21-2-2026.
Continuation.
Yes.
What modification was brought in here?
My lord, place of my lord, center was different center was where my lord attached. Baluki Salmara LP School, page 35. Then Baluki Salmara LP School, 71. Then these are the centers, man.
These are already there in the earlier order also.
Yes.
But what changes were brought?
But this is a fresh order, my continuation of the earlier.
That continuation is not there.
My lord, start with in supersession of all the earlier order numbers so and so. dated so and so. For smooth conduct of forthcoming general election to the recent so and so, the following officers are hereby detailed as zonal and sector officers 22 number Mandia so and so. Same cases, my lord, out of same imping order, lordship has passed the earlier order. WCC 1823. Subject matters, everything same. The earlier order, my lord.
We have it.
Sorry.
We are just trying to understand why this order was modified. What is the change there? It's 21-2. 21-2 was superseded by the subsequent order.
Yes.
Why that subsequent order was passed?
Guideline, my lord, specific. Persons who are not covered. I fall with not covered.
No, you fall provided the earlier order. Provided the earlier order is considered to be an order. It's for the district election officer who's there.
Section.
What is the difference between this page number 34 of the repetition and page number 46 of the additional evidence? Why is it separate?
With the 21 March 2026 order. And additional affidavit.
That date we can see, but otherwise, what is the difference? Why the February order was superseded? But district commission, district election service. Yes. Serving as senior inspector auditor. It's transfer. Where is your name in this order?
Name, figure, in
Page number 31. Serial number 30.
lordship. 30. Yes.
Serving as senior inspector auditor. Yes, and instructor society. Better. It's transfer. So, send instructor society. Submitted. Reflected in the appointed sector officer. CI notification itself as per clause 7 within bracket over 3 is to be exempted. Transfer the CI. So, we have to submit. Sense. So, still, as he has been appointed sector officer by the election department, district election officer and the deputy committee submits that his representation is to the secretary for election department. 6 has remained pending and hearing. Matter was listed on the 22/4/6. Liberty with the Standing Council, CI as also State Council. Their instructions. And submits that sector officer 6 issued by the district commissioner of district election officer. Subsequently came to be seated. 6 say by the same order also petitioner sector officer Legislative Assembly constituency LSC hyphen 25 hyphen Paka Betbari LSC. CI guidelines. Identification effective. Standing Council for the Cooperation Department of the Service. Transfer on respective petitioner. So, yes. Circumstances. sector officer. Prior to the transfer of the proceed. 7-3 is the sector. Identification. 7. Action used by the respondent of the petitioner. Sector officer of the 21 6. Attention. That will mean that on the date when say notification. Say notification. Appears as a civil sector officer in respect of LSC hyphen 25 hyphen Hakapen LSC. So, the subsequent notification will 6. Succeeding the early notification. Having been issued to the due have no bearing. Have no effect. As and subsequent as civil sector officer, respect to LAC 25. Six insofar as the petitioner is shall not be given effect to veterinary services in this purpose of posting, which is practice of the still registered cooperative society for better. Extending vessel infection, which the results are scheduled to be declared on 5th of May. Pending. They are concerned, you are concerned with the benefit of being excluded from transfer till the election. 4 weeks, later than 4 weeks. Respondent being represented by the respective council. Necessary affidavit. This matter after the returnable date. In the second writ petition,
My lord, the initial order was issued on, my lord, 11/2/2026, page 45, my lord. Yeah, my additional affidavit.
district commission and district election officer should on
11/2/2026.
11 sector officer, civil sector officer, respect to 55 number being LC. Senior inspector slash auditor.
My lord, imping order, my lord, page 36. His name figures in serial number 2.
It's same order, 15. His name appears there.
Serial number 2, my lord, page
Serial
36.
So,
And the second order, my lord, second order was issued on 15/3, my lord. Again, election officer has
election.
the date of the imping
Subsequent
order.
order. Here is the second order.
Second order was page 31. Name appears in page number 33, serial number 22. Serial number 2 and 22, my lord. Second of 22, serial number zone 2, page 33.
This is in Rupoyat.
Oh, yeah.
subsequent order by the district election officer. 15th position of the earlier order. Petitioner was appointed as civil sector officer for sector 22. 6 before he had LAC. Obliged. Yes, they have agreed to settle.
Let them approach the bank with proper documents. Bank will come.
In terms of the,
No, no, they have agreed on the agreement. Which has been
But
made.
they have to verify the KYC required document.
Verify, but we are recording your presence.
Yes,
Have
ma'am.
you been served with the agreement?
Yes.
You have been served.
Yes, sir. I have got it.
You got it. Is there any, according to you, is there any difficulty in the proposal which they
No, my dear, no, my dear.
vis-a-vis the procedure?
There is no difficulty. It is their account. But they have to fulfill the requirement of the bank, like proper document.
What is claims to be the first wife? Petitioner,
I'm the second one.
second wife.
Petition number 1 is the second wife,
Petitioner. One, second wife.
and petition number 2 is the daughter of the first wife since deceased.
I'm
Daughter
told
of the
that the
first
pet-
Let
wife.
it be on this way on the dispute who is the first or second wife. We are co-wives.
They
We are
they-
co-wives. Petition number 1 and respondent number 7 are co-wives. And the petition number 2 is the daughter of the first wife who is deceased. That's all.
At present, there is 2 wives and 1 daughter.
Yes.
Said there were more than 2 wives.
We have 3 wives.
in the morning I said there were 3 wives.
First wife is there.
The petitioner number 2 is the daughter of the first one.
For the first wife. Your Lordship has the agreement, the joint agreement, page 118. We have detailed very correct, accurately.
He's unmarried.
Yes, unmarried.
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 We can't order regarding your entitlement because it's only the first wife who is entitled.
No, not on the pension part. We are on the account, whatever is lying in the account. We are into joint agreement, that 50% will go to her, Shikta Das, and the remaining 50% will be shared 25% by the petition number 1 and 2. This is on one.
What will be the effect of the order?
The effect of the order would be minimal. Otherwise,
You are agreed.
My Lordship.
Both of you have agreed.
Agreed.
Terms of agreement.
Agreement.
It is not under directions of the court.
No. The issue was
Not under directions of the court.
My Lordship.
That you go for mediation,
My-
settlement, whatever, nothing. You have decided to agree.
My Lordship.
You have agreed.
We have agreed.
You withdraw the petition, file your agreement with the bank. Why you want a order from the court?
So if that direction is also there, we
What
can find.
direction?
But they may obey. That's all. We are in the agreement.
Right,
We
because
can only
initially,
say
because
that,
initially
we
the
can
bank
only
has
say
refused.
that the parties have agreed.
No, initially the bank has refused. My colleague would also consider it.
Initially the bank has refused to pay since they were rival claimant. So now we have settled the matter.
Right.
So in terms of the settlement,
Easier.
the bank has agreed to pay.
We are not deciding on your entitlement. Get the point. You are before the court asking for the amount lying savings account number so and so, so and so, so and so. We are not deciding whether regarding your entitlement. Right? So you on the other end have settled the matter outside the agreement. We can only say that in view of the agreement arrived there, nothing further needs to be dispose it off. The parties will appear before the bank authority.
Yes, sir.
Will verify the credentials. And
Oh, yes, not
Yes,
that what.
Yes, that's what we are.
That's not.
third counsel for summons. Petitioner number 1 and the respondent number
7.
7 are pre-white. Let Vijit Das. Bank, sorry, employee of the bank.
Yes.
He died in harness.
No, no.
He died while in service.
1 second.
Huh?
Yes, 1 second. 28 to 70.
No, no.
Oh, no, no.
He retired between 70. He died on
He superannuated from service.
28 to
Drawing his
70.
pension
Died
and
27.
subsequently expired on
28, 7, 25.
28/7/2025. Petitioner number plus marriage. First wife. The name of the first wife.
Suchibrata Das.
First wife, one Suchibrata Das. Subsequent. Petitioners before this court are filing some petition in respect of the bank account. Respect of the page number 14
Biologics. Those are the bank accounts.
of the deceased,
Deceased.
all in the same bank.
Same bank, different branches. 80 Road, Fancy Bazaar, and Gormata.
Respect of the following bank accounts,
Punjab National.
which are lying with the Punjab National Bank, but at the respective branches against the claim of the petition. Legal year, which the bank had refused according
Earlier they have not approved.
to the petition. So, there are no seven. Power. Responding 1 to 6. Para the independence of the petition. 7. Sorted out their differences and have agreed share the amounts lying in the bank account of the deceased so and so. Going down the terms of agreement. So, from the council of the bank. Since the petition 7 actually agreed. Decided on the two parties, bank authorities, and furnish copies of the affidavit,
Certified copy of it.
certified copies of the affidavit. Thereupon, bank authority will take decision take into account the derived by the parties, and if the same is as per procedure, then the understanding in the name of it thus shall be released as per the agreement arrived at by and between the petitioner. 7.
Proceed within a fixed time frame.
Needless to say, the petitioner will abide by all the exercise. Made clear that this petition purely basis of the agreement arrived at by and between the purely submission by the inspector. This exercise we carried out by the bank.
1 week notice.
No, no, 4 weeks after receipt of the representation.
30 days from the date of receipt of the
After receipt of
representation,
the
along with all relevant papers. Disposed. Interim order with any stand vacated, pending either
Go back.
Christmas.
We need some time to file our affidavit. Thank you all the rest.
Sir,
M. Google.
and Google. PS4, PS4, then file necessary affidavit. Instructions are waited in case of 4 weeks time. It's after 4 weeks.
For date, Mano.
8th of May.
41
is similar.
41 similar. Same day.
Okay.
Can she kindly pass over the matter?
Matter be passed over the day the request made by the council.
Kindly for the timing, that is considered in another court.
He is here. Here.
Item number 42, I am appearing on behalf of that agency. We have not received the instruction.
Mr. Kalu, Tovildar submits the instructions are awaited. This matter again after 3 weeks. Yes.
last question, the lawsuit directed the respondent department to supply necessary instruction to Mr. P. Nair. In connection with payment of VRS and other.
DCL.
Assam and Plantation Growth Development Corporation.
So respondent 7.
I am representing my.
You are representing. So you release that amount?
But still amount of financial sanction issued for 42 lakhs.
Out of which 2 crores have been released.
Crores has been released, and the petitioners have already received.
They have received.
But they have received on verbal inspection I have can come to know that and the remaining amount will be released during this time.
It is their instruction.
They have taken it.
Bring it on record. Bring it on record. So for the respondent 7 submits on instructions that an amount of rupees 2 crores have been received. Disbursement for PRS. Same has already been done. The persons to the concerned person, how many writ petition? One.
16 or 16.
Huh?
16.
Including the writ petition.
Only six have got PRS. Others 7 are retired and 3 are only 6 out of.
Whatever you want to say, bring on record. Counsel for the petitioner on the other end disputes the contention, submitting that stated to be disposed of with receipt. Considering the submission of that the counsel representing the respondent 7 bring on record particulars of the payments stated to have been made to the debt petitioners. Let this affidavit be placed on record within 2 weeks. List again on 8th of May. Mr. T.C. Sutia, ABS for state. Respondent. Very final report.
But we had filed an affidavit on the last occasion, no?
Any rejoinder required?
Required. It is complete.
What is the grievance here?
Sir, the retrospective promotion has given to some income tax. Out of those, promoted minor, government has given financial benefits to some persons to whom the retrospective promotion is given. But some persons, including myself, the government has provided a financial benefit. But benefit has been given to the juniors, who are also juniors. That's why it's granting financial benefit. That is why
It is submitted the pleadings in the petition. Changed. Instead for admission hearing or
23rd of April, madam. To be sure, it is not my good, madam. On the medical treatment.
not possible on 23rd. We can try on 30.
30th of April.
30. 30.
Alia.
Mr. Fugan for GAD. Yes. 30.
All right.
Lordship, in this matter, we have sent a betting your lordship. It is already ready. Private number file. Date may be fixed, man.
Respondent 8.
6, 7, and 8.
Private respondent,
Private respondent. You file.
They have already filed.
File.
State respondents represented by Mr. R.R. Gogoi submit that for the time be granted to file their affidavits. Counsel, the private respondents
6, 7, and
6, 7, and 8 submits that their affidavit is already been filed. dispute between the petitioner and the respondents, the cases in unit. Seniority list of the junior assistants. The affidavit of the department cell, the respondents, state respondents will endeavor to file their affidavits by the next date fixed. It's on the 8th of May. All right, ma'am.
Here is the last order, 13-2. As per this order, we have released the amount.
None appears to be. Turning down. Submits that the amount claimed by the petitioner in respect of leave
CPF.
salary and CPF
Yes, ma'am. That
has been released.
Yes.
Has
The
been
amount has
released.
been released. Gratuity has not been.
Huh?
Gratuity, madam, after the, instead of
Yeah,
the
or
release,
the
it on
claim
fourth.
gratuity is still remains accordingly. They have to be listed after.
M. Google.
Mr. Radhav, respondent. One end.
Last order, Lordship. This matter, Lordship, I was supposed to get the records, Lordship. Lordship, produce the records, Lordship. I was directed to produce the record.
It's made by the council for petition, that is still the record. It's tough to forward. It's to be implemented. The respondent can declare.
Thank you.
Have received instruction in this matter also. Affidavit to be signed. Kindly grant 2 weeks time.
My lord, kindly see, my lord, order date is 6/2/26.
6/2.
Yes, ma'am. 5 minutes. Interim prayer was there, my lord.
What is the interim period?
My lord, since August 2018 to December 18, my lord, the salary as recommended under 7th pay commission has not been paid to the person.
What is the interim order?
My lord, praying for direction to the respondents.
That is the final order. That will be the final order, if required.
Yes.
What interim order you want? You're serving, presently serving.
Yes, my lord, yes.
You're getting your current salaries.
Current salary as recommended under 6th pay commission.
You want it under 7 pay.
7th pay commission. My lord,
What's into that?
the recommendation, my lord, under 7th pay commission, since, my lord, August 2018 for 5 months. That is not
From August 2018,
18 to December.
December, not
December.
received.
Only 5 months.
Thereafter it is received.
Received, my lord, but under 6th pay commission.
Date.
1 and 2 documents. 1 and
One and two filed their affidavit. 3 and 4 is filed. 3 and 4 is filed their affidavit.
Yes.
Yes, sir.
Whose behalf are you appearing?
People file.
4 has filed.
Yes.
Then
Pending counsel is,
you are for
I am for 1 and 2.
1 and 2. Affidavit by 1 and 2. And respondent 5. We file by the next 8 weeks. Start the whole week.
My lord, interim clear.
What interim you want?
My lord, salary for 5 months, my lord, has not been paid.
That will be a final relief. Final relief.
No, my lord. Finally, this, my lord, the salary under my lord, as recommended in the 7th pay.
Dependency of the petition, be a bar, respondents to consider. Petition. Salary which they claim has been released 5 months with effect from August 2018 till December 2018.
Selection of the petitioner as radiographic technician, manner.
Affidavit has been filed.
Yes, my lord, I have filed affidavit.
You want to file a rejoinder? No.
No, minor, because they have admitted that the petitioner is eligible for the.
My lord, at para 6, we have stated, my lord, that on review of the documents of the petitioner, he has been found eligible for the post.
Then you consider it,
Yes,
reconsider it.
Yes, we consider it.
The council, the claim of the writ petition is that although the petitioner was shortlisted on the basis of marks secured in the written examination and was directed to appear, skill test and document verification to radiotherapy technician petition selected. Claim of the petition that it satisfies all the norms and qualification, therefore his selection would not have been overlooked by the respondent. Pursuant to issues of this, the respondent 3 has filed an affidavit where at para 6 the following amendment is made. Para 6 extract. So the affidavit seen that the respondents have verified the claims made by the petitioner and has found that he possesses the required qualification as per the advertisement and therefore to radiotherapy technician. Such categorical stand of the respondents, it is clear that the claim of the petitioner present proceedings is well founded. So accordingly, the writ petition stands disposed of. Writ petition stands allowed with the direction to the respondent
Number 3, my lord.
respondent number 3, namely the Director of Medical Education, to consider the appointment of the writ petitioner, the post of radiotherapy technician, the basis of the basis of the basis of the findings. Petition stands alone, directing the respondent authority to issue necessary orders for appointment of the petitioner as the post of radiotherapy technician as pursuant to a review undertaken by the department. The petitioner has been found satisfies the required minimum qualification as per the advertisement. Is there any further tests required to be done? No. Let the order of appointment be issued immediately within which time?
4 weeks time.
Weeks. Weeks from the date of receipt of a certified copy of the order. The petition is now disposed of. Interim order then stand marked. Pending eyes of this.
Obliged.
Pension loan also. 9(3), Lordship, Director of Pension was supposed to get instruction.
Yes, Lordship, I have received instruction, Lordship. As per our instruction, the proposal of the commutation of pension to the Chief Executive Officer Bongaigaon, Zilla Parishad Bongaigaon, with a request to submit the application along with proper medical certificate issued by the authorities medical board. The proposal is returned to the Chief Executive Officer Zilla Parishad to to resubmit with proper medical certificate. That instruction I have received.
Submit the
Yes, that is not received by the Department of Defense.
What medical certificate?
Proper medical certificate issued by the authorities medical board. We have communicated to the standard letter to Bongaigaon Zilla Parishad. Instruction from Zilla Parishad will be required.
Friends, you're representing which department?
Pension and public.
You have written back to the Zilla Police.
Yes,
Asking for
with proper medical certificate or medical.
what was the medical certificate submitted? It's here. Medical certificate. Page. Control.
Check with the Zilla Parishad.
What is the proper medical certificate?
Here it is mentioned in Form C, Part 2, Part 3, and Part 4. Countersigned by the Chairman, Member Secretary, and other competent members of the Medical Board, that is Borpeta Medical Board. Petitioner have to submit it if it's
Are not verified by the medical board. So you'll have to submit it to them. You will place it before the medical board. Thereafter, they will forward it to the. What's your instruction? Some instruction you want?
Last page is the communication.
Mr. Ghosh, what do you say? You are referring to this 5-2,
Last page.
last page. The State Council has submitted with the court instructions that the medical report petition is submitted, turn back to the Bongaigaon Zilla Court. The request to submit the following, the request to submit the documents mentioned in the communication. Medical report done by communication dated 5/2/26 with the request to submit the same with the documents mentioned therein, namely one, there are Mr. Ghosh, learned counsel appearing for the respondent authority, submits that he would like to complete his instructions as to the further steps that are required to be taken by the Departmental Panchayat and Rural. This matter again after 4 weeks, enabling the respective council with their instructions. Date 11th of May. Silent instructions. Yes.
During the pendency of this writ petition on 10th of March 26, the respondents have taken out a office order, a corporate HR circular, in which they have approved a modification in the scheme of engagement. This has a direct bearing on it. We have filed an IA based on this. And this is gone without our knowledge, nor with the knowledge of.
What is it?
They have modified it and they have said that wherever the period of 4 years has been mentioned, the same should be as 5 years. So that means the persons who I was supposed to understand that has been extended by another 1 year. So the very basis of urgency which they have stated, that falls. They have taken this out on 10th of March during the pendency. We have filed an IA, Lordship. Today, we have filed it today because we got it on Saturday. We have given a call.
This is quite an unnecessary attempt. My lord, the case when a lawsuit other day directed us, please the record, we have placed it by filing an affidavit. The lawsuit can see that why, whether there is a administrative requirement is there or not. Now, by extending the person's for another 1 year. How will it affect these things? How the transfer order is initiated? They will have to, Your Lordship, let them satisfy the case. If the transfer order is initiated by malafide action, that's a different thing. Or if there is a, my lord, the violation of transfer policy. Unless you can show all these things, my lord, every day you will come up with an installment basis. That will not do, and whether it affects his case, that's the question. This is an unnecessary petition, my lord, Your Lordship can ignore it and let him satisfy Your Lordship how the transfer order is issued.
Lordship, Lordship,
Yes.
Lordship, they have based their whole premise and which they have repeatedly emphasized at para 11 at page 81, again at para 13 of page 82, that two contractuals are retiring in April 26. So they have, in fact, instead of a 3-leg stool, they have put it on a 2-leg stool. And this also collapses with this. Secondly, my learned senior counsel, he has not denied that this circular has been taken out on 10th of March during the pendency of this.
What is the effect of this?
The effect of this is that the employees whom they had said is supposed to be replaced and who was supposed to retire in April 2026. Now they are retiring in April 2027. So the whole summarized, and they have repeatedly, at like I mentioned,
Where in the affidavit have the statement?
para 11 at page 81.
Affidavit or in opposition?
At page 81, at the affidavit in opposition. Page 81, affidavit in opposition. Lordship, if you look at the last line, which is this thing, and their contracts. May I read, Lordship? Thus, only 2 numbers of contractual employees female are presently working in the respondent number 1 company, and one of them is posted at Corporate Law and Arbitration Department, Rishikesh, and the other at Tehri Project, which is 70 kilometers away from Rishikesh, and the contracts are set to expire in April 2026. Again, we come to page 82. Page 82, para 13, Lordship, that the deponent states that out of the 13 legal executives who were recruited during 2022-23, only 5 are presently working in the respondent number 1 company, and 2 of their contracts are set to expire in April 2026. That apart, they have given that this is the deficiency which they. So that whole summarized. Again, I'll read at page 98, para 31C. That there is an acute shortage of manpower. The whole summary summarize on which they have stated that there is an acute shortage of manpower, and the non-joining of the petitioner would further exacerbate the crisis in as much as the contract of another law officer is engaged on fixed term basis is expiring in April 2026. All of this now become 2027. So the whole summary, the base, the foundation which they have built up of urgency, and that is why that gets destroyed. So
First thing is that you are an employee of the corporation.
Lordship.
There is a policy, that policy
I'm
is
supposed to,
according to them,
Lordship,
this is an exigency of service.
Lordship.
Whether somebody remains in service or not,
But
cannot be a ground that you shall not be transferred if the authorities feel.
Lordship,
You have not made any allegation specifically
Lordship.
in respect of malice against any of the officers.
That's taken. And so that we can then, once we have a hearing,
Hearing will have, but it's a question of see, extension of somebody's contract,
Lordship,
how does it give you the benefit of retention in a place which, according to the department, your services are required elsewhere?
first, Lordship, that is where the malice comes in. Because Lordship, I was, as per their own guidelines, I was supposed to be there for 5 years. They have posted someone in my place, which they could have kept him out there also. They have posted someone. So that means the not.
To understand, firstly, that your contract of service, your relationship with the employer is that you are open to transfer. Now, there is a policy which normally is required to be followed. If it is not followed, then it must come with specific affirmance that this is not followed for X, Y, Z reasons, and which are directed primarily to as a source of harassment to you. And if you do so, then you will have to array these people who have issued party respondent so that they get an opportunity to work. Number two, that the regulations otherwise, if interpreted, reflect that this kind of transfers are not contemplated. Therefore, by wrong reading or wrong interpretation of particular that attempts can be made that it is a malice in law.
Yes, Lordship, that is meant. Because I have been repeated. They have defined their own guidelines repeatedly. And this is in, as a young girl.
What are your guidelines here? Yeah.
The guidelines, Lordship, I'll come to. 101. Lordship, may I draw your attention? Lordship, may I draw your attention to page 29. 29 of the writ petition, annexure 2. I would draw your attention, Lordship, to para 6. Para 6.1. May I read? Tenure 6.1. The normal tenure of posting will be 5 years for executives and supervisors. I am an executive, Lordship. So this is applicable for me. Thereafter, they have talked about workmen, which is not applicable. I draw your attention to specifically para 6.2 and 6.3. Para 6.3, criticality of manpower for the donor and the recipient department, project or office, employees will be considered for transfer. They will be considered for transfer after they have spent a minimum tenure specified in clause 6.1 of the means the consideration itself has to be there only after they have spent 5 years. And I have just spent exactly 2 years. So they have gone against their own policies.
But what do you say that 6.2, the last line?
6.2.
Last line, last sentence.
Lordship, employees will be considered for transfer after they have spent a period of 5 years, except in case of exigency of administration. However, employees both in technical, non-technical discipline may be required to stay for longer period at one location owing to organizational requirement. Further, employees may also be transferred before expiry of tenure based on organizational requirement and administrative exigencies. Now the question is, there is an organizational requirement or if there are administrative exigencies, then they would not have posted someone in my place. There is an experienced officer whom they have posted in my place.
Like if they wanted someone to stay in the corporate headquarters, from there, if they're lifting someone and putting out here, where I am already there and I have not, so that shows that there was no, that means I have been specifically picked up. And this,
That is the case, then you have to make allegations against the officers concerned. You are alleging malice,
we are,
but without naming them.
we have, because it has all come officially under the official signatures.
Whatever it may be, if it is your case that you have been targeted by officers in spite of there being other options available, and for whatever reason you have been targeted, erase those options as a party response. Otherwise, how are you making this allegation? They are not getting an opportunity to rebut.
But because as a woman, I have been transferred, and when I was transferred,
Mr. Counsel, you're building your case on harassment,
absolutely.
right? Now, who's harassing you?
The organization, in terms
The
of the
organization
officers,
is represented by
by
some
certain
officers.
officers,
Who are these officers harassing you?
those who have issued my transfer
So
order,
you have to array them as parties. Why have you not arrayed them as parties?
they have been arraigned. Of course,
How
they
can
have,
you make this allegation of harassment without giving them any opportunity?
Lordship, as far as the respondent number 2 is the executive director. And
But you have to array them as parties. Cannot allege personal bias without giving them an opportunity.
they are arraigned as parties. The respondent number,
Not by name.
not by name.
Who is the person? Who's the person against? See, it is not the office against whom you are making allegations. Perhaps you are making allegations against specific person. Who is this person?
These
Unless
are
you
the
are-
appointments which they are, these are the appointments which they are terminating, the executive director. We have not put them as personal.
You have to. Otherwise, how are you alleging malice, personal malice? You're saying that you're being harassed.
Harassed, we have been made a victim. And the facts clearly prove that. And there is a long list. It's not only one. There is a series of.
What is the ground for transfer here? What is the averment of the?
They have given the advertisement that they have this thing, that contractuals which I mentioned, that they are retiring, they are facing a shortage. So that ground is gone now.
Where is that?
I mentioned para 11, page 81. Para 13, page 82. Para 31C at page 98.
Para 31C.
Para 31C at page 98. There is an acute shortage of manpower at the corporate law and arbitration department and the non-joining of the petitioner. They are talked about acute shortage of manpower. And the non-joining of the petitioner would further exacerbate the crisis in as much as the contract of another law officer engaged on fixed term basis is expiring in April. So here they have extended, but they are mentioning that any further extension in favor of the petitioner would impair the effective functioning. Now, the clause does not, because they have, by this circular, dated 10th March, the terms have been extended, and there is no denial from the respondent side that such an action has been done.
What do you say, Mr.?
Should I take your lordships to the
Your ground for transfer of the petitioner is, appears to be acute shortage of manpower.
yes, yes, still it is there. I'll be satisfying your lordship. Your lordship, kindly come to page 189. Your lordship wanted to see the file noting and all that. So your lordship will find that at page 189. From the middle part, your lordship can see. In recent past, some of the employees of this department as given below have either been
You're reading
page 189.
189.
Right.
Yes, it is note number 1.
In the middle,
Here about line.
in the recent past from there, exactly at middle. She got
Trying to locate it.
in the recent past. Above the table.
Above the table, okay.
The recent
Yes.
past, some of the employees of this department as given below have either been superannuated, transferred to other departments, project, or resigned from so and so. The lordship will find these are the persons who will find the superannuated, 3 persons resigned, and transferred. Presently, over 276 cases are being dealt by corporate LNA, which are pending across different courts and forums, cumulative to a significant amount of contingent liability. Apart from legal examination of providing legal opinion, legal vetting of documents referred to it. Then your lordship will find this table again. The present strength of manpower other than HOD is main in corporate LNA. Here in the next page at page 190, lordship will find 14 officers. Out of them, your lordship kindly see 6 and 9. 6 is Mrs. Priyambada Peru. Now, she has resigned on 26/12/2025. And the other person, at 9, superannuated on July 2025. So, acute shortage.
Which is the other person?
This at 9, serial number 9, you know, S.S. Rangan. He is superannuated on July 2025. Then your lordship kindly come to the next page at 191. Light of present position of works in hand, vis-a-vis available manpower, necessity of induction of at least 2 executives is being felt for smooth running of corporate and LNA, which is reasonably justified from the position brought out above, showing the executive left out from this department on different counts in recent past, along with the position of works being handled by the department as I say. Accordingly, it is proposed to kindly depute at least 2 executives in corporate and ALA department by transfer from other department as per the following. Now, in this table, you will also find R.D. Rathod is Deputy Manager Law. He was presently posted as Company Secretary of it. Then discussion was held with the Secretary and they said that they can spare him. Then MS Sweta Bhattacharjee, the petitioner here. Now, she was at Arunachal Pradesh. Discussion with the HOP Arunachal Pradesh spare her. So, your lordship will find this note was prepared on 16/4/2025. They felt that the necessity of the 2 executives were there. Then, as your lordship, I have shown S.S. Rangan, superannuated on July 2025. That was necessary then. Then, Priyavada, as lordship has seen that she resigned on 26/12/2025. Because of this resignation, the 2 executives are necessary there, and the note is made according. Now, ultimately, my lord, she has been transferred, keeping back in mind the administrative requirement of the. So, the corporate and LA department, the main department, my lord, where we need maximum notice. And the other 2 persons where my learned friend has shown that their term has been extended It is recently, it has been extended after filing of our affidavit. Now, if it is extended also, how this transfer order is received? He has to show that.
They are trying to see that the exigency expressed
Yes, yes. Whether it is there or not.
is not there in view of the extension of the period of.
Extension, my lord, even then, if they are still there, my lord, because of the resignation and superannuation,
Where were they working?
my lord,
Where were these two persons working?
in corporate.
Where in the head office?
Yes,
Head office. Their terms have been extended.
nonetheless, my lord, because two other officers already gone in the meantime. So still shortage is there.
What is the requirement in the head office?
Lord, that your lordship we have explained in our affidavit. I will take your lordship to that. Kindly come to page 120, page 124, paragraph 5. The Corporate Law and Arbitration Department, Rishikesh, was formed in the year 2007 and being an important and sensitive department entrusted arbitration matters, legal cases, which and discipline matters from rendering and obtaining of legal opinion, various issues and writing documents that arise from time to time. The workload at the Corporate Law and Arbitration Department has been constantly on a rise. The respondent corporation has diversified its business and its installed capacity has significantly increased from 1587 MW to 3657 last 2 years. However, due to superannuation and resignation of employees from corporate law and administration department by the GM, was seen just now. On 16th to 2025, query workload on the department was described along with and transfer from the department. Further, the sales proposal also contains slide proposed the transfer of place for posting corporate department. Pertinent to discussed with their department heads that they were ready to spare the seed employee. The seed continuing was further highlighted that one regular executive head could have has tendered her 11 number of the cabinet. Designation, therefore, a law professional was required in India. Thereafter, upon internal discussion, Mr. R.D. was transferred to one Mr. P.S. Patil. Manager law was transferred from Jaipur to Corporate Law and Arbitration Department, Rishikesh. So, against the requirement of two executives, only one executive was transferred to the department in April 2025. It is highlighted here that though GM proposed the name of Ms. Shweta Vidyarthi, the petitioner hearing transferred to Rishikesh long back in April 2025. However, at that time the petitioner was not transferred. Following month, the department at Rishikesh superannuated in July 2025. One regular employee, S.S. Rangan, officer law, superannuated in July 2025, and another fixed term employee, M.S. Priyamadu Benaru, resigned in December 2025, which immediately got the requirement of a bright and young law professional. The department of Rishikesh. The petitioner was transferred to Rishikesh. Further stated that one manager law posting for Because in above circumstances that the proposal note stating residential needs dated 1/1/26 for transfer of Mrs. from Arunachal Pradesh to project 1/6. And this is the background, my lord. Therefore, my lord, there acute shortage of the law officer in the corporate offices still persists. And my lord, in saying and accept saying that the Malay is in law, lord, you say that, my lord, I will take you nothing squarely on that point. I take your lordship to paragraph 14 onwards, 16. Paragraph 16 of page 93. The act of transfer can be unfair labor practice if transfer is actuated by malafide. The allegations of malafide are facets. One, malice in fact, the other being malice in law and malice in fact. The challenge to the transfer is based upon malice in fact as with an action taken by the employer on account of officers present in conference. Judgment also, this court held that malafide means want of good faith, personal bias, grudge, oblique or improper motive or alternative purpose. The proof of malafide involves questions, namely, whether there is a personal bias or an oblique motive, whether the administrative action is contrary to the objects, requirement, and conditions of exercise of the power. As far as second aspect is concerned, there is the power of transfer vested in the employer in terms of letter of authority. Here in terms of the position of the act, the transfer by itself cannot be seen unless it is actuated by malafide. Therefore, to sustain the plea of malafide, there has to be an element of personal bias or school held under malafide means what want of great personal bias in right or improper motive or alternative part. Administrative action must be safely done if it is in fact done honestly, whether it is done negligently or not. An act done honestly may have been done. The administrative authority must act in a manner and should never act for an improper motive or alternative purpose for contrary or the basis of the company or improper discretion to achieve the alternative purpose. The determination of the malafide, there is a personal bias for an object and whether the administrative action is contrary and conditions. The action taken must therefore be made malafide for such consideration. Here is asking for a vague bold statement. Such must be demonstrated either by admitted or proved facts and circumstances of the if it is established that action has been taken malafide any such consideration or by fraud on power or colorable exception power not given. Malice in law inferred wrongful act intentionally just for excuse or without there being reasonable relation to the purpose capable of power. Malice in law is not established from the omission of concerns and documents. Safety will never be cannot be held to be tolerable exception but fraud and power. It may be honest and one of such is with power. There are no grounds made out or shown to us for the past information. This is an authority for the proposition that the existence of therein despite the attempt by the respondent to prove by affidavit evidence corroborated by documents of the malafide facts of the Then paragraph 17. Another judgment, Prabhat Sagar versus Punjab.
You
Yes, sir.
get that IA will take it up tomorrow.
Sorry.
IA.
But we have one more than one.
Can be done.
Leave of absence has always.
Because you are enjoying the stay order, they are pressing the vacation stay order.
Lordship, it may be taken
Immediately, think it done.
Lordship,
We have no
but
difficulty.
Lordship, why I say that is, I was listening to him.
The application filed
Annexure
with SIM
J,
intended to
Annexure J, which he
get
was
rid of.
referring to, Annexure J at page 191. Lordship, why I say this is a stale and irrelevant noting. So I was thinking it is 26, but this is 160425. So he has referred to a noting which is 1 year back. And the interesting part is, Lordship, Mr. R.D. Raturi, whom he referred, serial 1 at page 191, the table. He is the one, they are having deficiency, but he is the one who has come to non-sign to relieve me, which itself is so contradictory. This has no proximate nexus with the impugn transfer order. This is 1 year old, and it is basically, Lordship, a clearly afterthought which they have introduced to lend a post facto justification to what is otherwise an arbitrary action. 1 year back,
Where is the transfer order?
Lordship. Lordship, page 26.
It's 2126.
But yes. 26 to 126. And Lordship, this transfer order was given during my leave period when I was on authorized leave, and they have themselves admitted that it is admitted fact that the transfer order was given and they asked me to join during my leave period itself. I was on leave till 18th of January, and they have given on 2nd January 2026 and have given me exactly 7 days. 9. Whereas I was already on leave. That itself is malafide. They have admitted.
And we have extended by 2 months when she represented.
When we came to the court on 19th, we filed thereafter. Thereafter, they woke up or they responded. And this was given during my leave, asking me to join on 9th. Whereas they had themselves given, knowing that I am on leave till 18th, 19th. This itself proves the extent of malafide is there. Now, coming back to page 191, Mr. R.D. Raturi, that sale note sheet of 1 year back, April 2025. This is just an afterthought. They are trying to combine, justify. In fact, Lordship, if I come to the IA at annexure 1, Lordship. Lordship, page B. Okay. Today we have filed it. I think it's not come on record.
Mr. Doctor, you agree on a date, we'll take it up. Finally. Day after is the last date, it will be difficult for us to complete a hearing.
Intention, my lord, of filing this IE, get only intention of the petitioner, what I can understand,
No, but
to extend the period.
whatever it may be, but there are substantial issues which have come up. We'll have to look into all that and pass a detail.
That is,
So,
see that. But then, says substantially key, they
They're-
have filed it. They could
they're
not
trying
show-
to project a case of malice.
Right.
So that we'll have to.
Is there any foundation? Got to that?
We don't know, we'll have to examine. That's what we're saying.
Whatever we have argued past, they used to show that foundation has been laid. And if you make any sort of license law and all that, you'll have to incorporate person. Is who is- Let me finish. There is a system in this code. When they're saying that some malafide action done by some officer, are you making them party? You'll have to do it, otherwise you'll space.
Examine that.
Because on
Let
that
it be
issue
on
only,
21st.
Can you 22nd?
Can't fix a
No.
date. That's why you have
Any,
to-
any date, sir, except.
Third.
Not.
ultimately, your lordship is seen. The representative filed by them, they have said. Now, it was 1 year time, we have granted a 2 months time. So ultimately, it boils down to that there is nothing in the transfer order is done quite, my lord, keeping the.
We'll
law
examine
intact.
that. We'll examine that and pass an order on 23rd.
And 21st, my lord, I think my learned friend will make any sort of.
23rd.
23rd. All right.
We are not,
Can it be on
we'll try to dispose of the matter. Subject to
that case, my lord, will it be inconvenient if you look at take it from 27?
No, that's a miscellaneous day, because
Also.
we'd like to dispose it of, it will require some amount of.
Right, right.
28th is available.
28.
28th. Matter to be listed for hearing, admission hearing. 8th. And then wait to dispose of the matter. Same date. Interim orders and then next date of listing.
That's much of it. For Gary, but I think.
What happened in the writ appeal?
It's again 19th of 18/5.
You can go after the vacation, after the writ appeal order. It will be listed on 29th of May.
29.
As it is submitted that the writ appeal number 53 of 2025 has been fixed on 18th.